I would like to address all your members also, so that they are also aware of the consequences and of the remedies you can take it. So I would just introduce Dr. Samir Dalvie. He is an MBBS, Orthopedics, MS Orthopedics, FCPS, DNEB, Neurospinal Fellowship, Pediatric Spine and Deformity Fellowship, Adult Constructive Spine Surgery Fellowship he has done, and he is a consultant orthopedics and spine surgeon at present. He is a head at PD Hinduja National Hospital, Hinduja Healthcare Surgical, Bridge Candy Hospital, and is a chairman of AO Spine Indian Subcontinent. He has done his training and post-graduation from GS Medical College and KM Hospital. He has done his fellowship in spinal neurosurgery, Liverpool, fellowship spinal trauma and reconstruction, Stanmore, London, fellowship pediatric spine, Great Ormond Street Hospital, London. He is a visiting fellowship, Kleinman, Classbird, Germany, visiting fellowship, Leatherman Spine Center, Louisville, USA. His special interests are microsurgery of spine, reconstructive and implant spinal surgery, spinal deformity, cervical and carniovertebral surgery, and revision spine surgery. He has also authored books, and he has affiliations with Education Committee, member at Association of Spine Surgeons of India. He is a trustee, he is a chairman of Guide for ASSPI Spine Fellowship, teacher for DNV Orthopedics, AO Spine, India. So with that brief introduction, I would now request Pradeep Chandwani, our convener, to present a memento to Dr. Samir Dalvie. Samir Dalvie, sorry. Thank you very much, all the members. Now I would request CA Anup Shah to please take the charge of the session.
Maybe important from a client's perspective. This is something which touches every single individual, because estate planning is as important as health planning. You have Dr. Dalvie speaking on health planning. This would be about your financial health planning and what you're leaving behind as a legacy for families to come, both from a professional practice perspective as well as for us personally. So what I'd like to do in the next couple of hours is to give you a brief snapshot about estate planning. What happens if you don't plan? Because that's very important. In India, the general trend use on a multifold. So yes, it is increasing, but no, we haven't reached where we should. If you look at the West, every adult, and when I say adult, everyone over the age of 18 owning some sort of asset has probably made a will or has thought of something. Whereas it's not even in a micro percentage when you look at it from the Indian context. So what happens if you don't plan? What happens if you decide to plan? And what are the planning options? And then a little more about the different ancillary facets which one comes across when you look at estate planning. So when you look at the scope of estate planning, it's death, that's the basics, nomination and will. HUFs, very popular in the Indian context. As chartered accountants, we're very familiar with HUFs, but we look at it more from the tax angle. Let's look at it from the legal angle. Incidentally, what I plan to do today is not touch upon tax. That could be a separate topic by itself, and I don't want to get into a micro level of estate planning, which is taxation. I want to look at the broader legality perspective, which is more relevant, because as chartered accountants, we are want to focus on income tax alone, and we miss the bigger picture. We're missing the wood for the trees. So let's look at estate planning in its holistic perspective rather than focusing only on the income tax aspect. Gifts and release deeds, very common and very important in today's context. Family settlement, when all fails and dispute breaks out, we have family settlements which are very popular. And lastly, family trusts, which are, according to me, are the most sophisticated vehicle for estate planning. And anybody above a certain net worth or with certain complexities in his lifestyle should look at family trust as the module for going in for that. What are the assets which one needs to consider when you're looking at estate planning? The whole gamut. Home, office, land, dispensary, clinic, if you're a doctor. Tenanted premises. Pagri premises, very important from a Mumbai perspective. And I have certain data, looking at how to look at estate planning when you come to the tenanted premises. Banks, fixed deposit receipts, insurance policies, arts and paintings. In today's world, these have become a very valuable source of assets for the ultra HNI. What happens to them? Digital assets. You have crypto assets, you have your bank accounts which are online. you have your email accounts, you have your social media accounts, securities, mutual fund units, foreign assets. How do I deal with foreign assets when I'm doing my estate planning? Do I have one will for global assets, or do I have horses for courses? I have a separate will for US, separate for India. Sorry? Yeah, I'm fine. I'm fine. So do we wait or? Okay. Is there any way we can? Because I'd like to show if it's possible.
Is this okay if this?
Yeah, yeah. Okay. So let's first look at what happens if there is no estate planning, which is the more popular way. As they say, he just kicked the bucket. So if a person dies and there's no estate planning, what happens? So in India, you could divide it into two different classes. Person who died intestate, that is, he did not make a will, or he died testate, that is, he made a will. If he died intestate, since we don't yet have a uniform civil code, the law will depend upon the religion which he was professing at the time of death. So Hindus, Jains and Sikhs would be governed by the Hindu Succession Act. Muslims would be governed by the Sharia law, and anybody other than that would be governed by the Indian Succession Act. So if you look at the slide, you have Hindus, Jains, Sikhs and Buddhists who are governed by the Hindu Succession Act. Christians, Parsis, Jews would be governed by the Indian Succession Act, and Muslims by the respective Sharia law, that is the Sunni Sharia law or the Shia Sharia law. If a person makes a will, then the will needs to conform to the legality laid down in the Indian Succession Act 1925 for everybody other than a Muslim. Wills by Muslims are again governed by Sharia law, but now the Indian Succession Act plays a dual role. A, it dealt with the intestate succession for certain communities, and B, it lays down how a will should be made for all communities, including Hindus and others other than Muslims, to make it a valid will. Now, what happens in case of foreign assets? And this is very interesting. For immovable property located in India, it is always the law of India which determines how the will should be made, means how the asset would bequeath if no will is made. Laws of India, that is the Indian succession law, will decide how the will should have been made by the UK resident. But if you're looking at movable property like shares, bank deposits, make will and intestate succession as per that law also. Now, what is domicile? Domicile is where you wish to have your permanent home. It is different than residency, different than citizenship. As certain authors would say, it is where you want your ashes to be scattered when you die. So ultimately, where do you say is my permanency of home, and what is your intention? One thumb rule is your father's place of birth determines your domicile. But some people say, no, I want to change my domicile. So then domicile could depend on that also. Let's look at the Hindu Succession Act when it comes to a person dying without a valid will. So assume there is a Hindu, Jain, Buddhist or a Sikh who has not made a will or who has made an invalid will. It would be decided as per the Hindu Succession Act. This act does not apply to anyone who is not a Hindu. So Muslims, Christians, Parsis, Jews will be outside its purview, and it overrides all customs and traditions. So all our Hindu mythology, anything laid down contrary to this law will not apply. Succession to property will now be decided by law. Now you cannot determine who gets what. Your legal heirs cannot say, no, I am the wife, I should get everything, or the son or the daughter cannot say, I should get everything. It is what the law decides. The law here classifies Hindu intestate succession differently for males and differently for females. Because always if you look at Hindu law, there is a different hierarchy for males and a different hierarchy for females. First, everything goes to his class 1 legal heirs. If there are no class 1, it goes to class 2. If there are no class 2, it goes to agnates. If there are no agnates, it goes to cognates. So this is the order of succession from left to right. What are class 1 legal heirs? Son, daughter, widow, mother, and any children of a son or a daughter who has predeceased the Hindu male. All of them would be treated as class 1 legal heirs. Each of them is entitled to an equal share. Father is not a class 1 legal heir, but mother is. And daughter is at par with the son. So this is the order of succession amongst the class 1 legal heirs. Class 2, first is father. So if there is father, he gets everything. If there is no father, you go to brothers and sisters who get it equally. If there are no brothers and sisters, you go to grandparents from the father's side, that is paternal grandparents. No paternal grandparents, go to maternal grandparents. No maternal grandparents, you go to parent siblings, that is uncles and aunts from your father and mother. This is the order of succession amongst class 2 legal heirs. Assume there is a person who has no class 2 legal heirs also, then it would go to his agnates or his cognates. Now agnates means somebody who's related to me entirely through males. Means the commonality between that person, whether male or female, and me is entirely through males. So my father's brother's daughter, she would be an agnate because the commonality between us is my father and her father. Both are males. Whereas my mother's brother's son would be my cognate because the commonality between us are not entirely males. My mother, his father. So first agnate, then cognate. Hindu law, very male dominated, very patriarchal society, and therefore everything is males first, then female. That's unfortunately the reality of how our Hindu law is structured. So this is how we go 1, 2, agnate, cognate. Let's look at an example. A Hindu male died intestate, leaving behind a full family: mother, father, wife, son, daughter-in-law, daughter, son-in-law. Who would get a share? Mother, she's a class 1 heir. Father, he's not a class 1 heir. Wife, that's the widow, definitely. Son, daughter. Daughter-in-law would not get anything because her husband is alive. Had her husband predeceased his father, she would have got. Son-in-law gets nothing, daughter is alive. So there would be 4 shares, each of them getting a 25% stake in the estate of the Hindu male who died without making a will. In the second example, a person died leaving behind 2 brothers and 3 sisters, that is 5 siblings, and his mother's parents. Now all of them are class 2 legal heirs, but in the hierarchy, siblings come before your maternal parents. Therefore, his 5 siblings will each get a 1/5 share equal in his estate, and nothing goes to his maternal grandparents. Female intestate succession. What happens if a female dies without making a will? Here, there is no concept of class 1, class 2, agnate, cognate. Here, there is a different order of succession. But first of all comes the question to our mind, can a female own property absolutely under the Hindu law? Answer is a resounding yes. It could be property which she has acquired by inheritance, by partition of HUF. in lieu of maintenance from her father, or from her father-in-law, or from her husband, by gift from others, by own skill, that is by working, by carrying on a business, or by buying it. She can deal with this property in any manner she prefers. That's section 14.1, a very important section. And she can do whatever she wants with it. She could will it, she could gift it, and if she does nothing in her lifetime, it would go as per the Hindu Succession Act. Any property possessed by her is her absolute property. Now this causes and caused a lot of confusion, because Hindu women started saying that any property which I own becomes my absolute property. So even if I received the property with a caveat or with a condition, that condition is no longer applicable and I can deal with it in any manner I like. So there's a very famous decision of Sadhu Singh where a husband gifted a bungalow in Punjab to his wife with a condition that in your lifetime you will stay in it. After it, it goes to my nephews. The husband passed away and the lady started residing in the bungalow, and she wanted to make a will in favor of the Gurudwara, saying that I would want to will it away to the Gurudwara and not give it to my husband's nephews, because it's my absolute property under the Hindu Succession Act. I can deal with it in any manner whatsoever. The Supreme Court said no, section 14 is a shield, it's not a sword. You could use it for your protection, but you cannot undo what has been done rightfully by your husband. He gave you this property with a condition, with a caveat. It continues with the caveat. You cannot take shelter under this section and do away. The property will go to your nephews and not under your will to the Gurudwara. So if there is a condition in the property which you received by will or by purchase or by gift, that continues. But anything else is absolute property and cannot be taken away from a Hindu lady. What is the order of succession? First, it goes to her husband and her children. So son, daughter, husband, they have an equal share. If there are none, it goes to the legal heirs of the husband. So as if the husband died intestate under the Hindu Succession Act, it will go to his class 1, class 2, agnate, cognate. If there are no heirs of the husband, it will go to her parents, that is her father and mother. So her father and mother come at a very remote number as compared to the legal heirs of the husband. If there are no parents, it goes to the legal heirs of the father. And if there are no legal heirs of the father, it goes to the legal heirs of the mother. This is the order of succession from left to right. If you recall in the newspapers a few years ago, there was this legal case in the Madras High Court about late Chief Minister Jayalalitha, where her father's legal heirs and her mother's legal heirs were fighting about her estate. So she had two claimants. One was a nephew of her father and one was a niece of her mother. Ultimately, the Madras High Court decided in favor of the nephew of the father because he has priority as compared to the niece from the mother. So this is the order of succession, again left to right, but no agnate, no cognate, no class 1, no class 2. Exception, Hindu laws like a page turner of Agatha Christie. You'll always have twists and turns across the corner. Sorry? Sorry? Indirectly, yes, if there is no son, daughter, but yes, but not in the law. It only comes in through this. Exception, if there is any property inherited from her parents, very important, inherited from her parents, means she got it under will or otherwise from her parents. She dies without any children, means she has no son or daughter. And in such a case, property goes back to the father's heirs and not to her husband. So even if she has a husband, this property will go back to her father's heirs, because the idea is it came from her parents. She has no children, it should go back to her father's heirs and not to her husband. So this is a very important exception. What if the property was gifted by her parents? Then this exception doesn't apply. This is only if property is received via inheritance. Similarly, if she receives any property by way of inheritance from her husband or father-in-law and she dies without any children, then the property will go back to the legal heirs of the husband or father-in-law and not to her parents if there are any in the order of priority. So these are the two exceptions which we have in section 15 of the Hindu Succession Act. Two examples for a Hindu lady. A Hindu female dies intestate, leaving behind her husband, 2 sons and parents. Husband and 2 sons would get everything, 1/3 equal share, nothing to the parents. But look at the second example where the exception kicks in. A Hindu female inherits a house from her father. She dies intestate without a child, no son, no daughter. Leaving behind her husband, he will get nothing. Father's brother, father's sister and husband's sister. So who would get it? Father's brother and sister, they would be treated as class 2 heirs. Each of them would get an equal stake. Exception 15(2) would apply. Nothing to the husband, nothing to husband's sister. We looked at different classes for a Hindu male and a Hindu female. And what if there is an unfortunate person who has no relatives at all? In such a case, who gets it? So there's a saying which is modified, jiska koi nahi, uska government. Government will come and happily claim it. They will never let you down. So if you have no relative, do not fret. Government is there to take it. This is known very interestingly as the law of escheat. So it's as if it's a cheat on you. So the British common law calls it the law of escheat. If you have no claimant, Crown is your claimant. Government would take it over and treat it as the central government property. But they cannot just come and take it over. It needs to be done via a court process. It needs to be proved in a court of law that the deceased had no relatives, no legal heirs, no will, and therefore the government is the claimant to the same. Is stepson a legal heir? In this era of remarriages, double marriages, would a stepson become a legal heir? Very interesting. Our Income Tax Act, Section 2, defines a child to include a step and an adopted child. Based on this, several decisions, the plea was made that when the income tax law treats a child to include a stepchild, for succession law also a child should include a stepchild. But a host of decisions have held a resounding no. Hindu Succession Act is different from Income Tax Act. What may be a child under the income tax law is not a child under Hindu law for succession purposes. For these purposes, I would go by the General Clauses Act definition, which says only an adopted child is treated at par with a born child. A stepchild, a stepson, stepdaughter is not a child. Therefore, he would not or she would not succeed to the estate of the stepfather or stepmother, and they cannot have any legal claimant to that parent's estate. This is something which is, there is no contrary decision. It is very clear cut that a stepchild cannot be a legal heir to a Hindu male or a Hindu female. Of course, if you make it under your will, then there is no bar, because wills could even be in favor of a stranger. So then when you could will it away to a stranger, why not to a stepchild? What about an illegitimate child? A child born out of wedlock, which is not legal marriage. Now, if the marriage is not valid or is void under the Hindu Marriage Act, you have a Hindu Marriage Act also, which lays down the conditions in which a marriage between 2 or more Hindus would be valid. What happens to such children? Now, here the Hindu Marriage Act came out with a saving proposition in section 16(2) to say that it would be unfair on the child to treat him as illegitimate merely because the marriage is illegitimate. Therefore, it said even if the marriage is void ab initio, means it is not legal, any child born out of such marriage who would have been legitimate if the marriage was valid is considered to be legitimate. Very important, if the marriage was valid. So you had the recent same gender marriage case before the Supreme Court, where a lot of people said we can take shelter under the Hindu Marriage Act. No, because the child would have been legitimate if the marriage had been valid. The marriage was never valid under any situation. Therefore, children adopted by them or surrogacy through them, they would never be eligible for legitimacy under the Hindu Marriage Act. Supreme Court has said the Hindu Marriage Act confers legitimacy on otherwise illegitimate children. So even though they are illegitimate, they are treated as if they are part of the family of the persons to the wedlock. And children of intestate Hindu born out of void marriage were entitled to a share in his assets. So look at the dichotomy. Stepchildren not entitled. Illegitimate child entitled to. But there is a caveat by the Supreme Court that the Hindu Marriage Act confers no rights in the property of any person other than parents of the illegitimate child. So he cannot make a claim to grandparents, uncles, aunts, all of them. He can only make a claim, or she can only make a claim to the father or mother's estate, not to anybody's estate, by taking shelter under the legitimacy given by the Hindu Marriage Act. A couple of months ago, we had a very interesting Supreme Court decision. Can an illegitimate child who has now been treated as legitimate because of this law claim a share in the father's HUF property? So, as you know, that a child automatically becomes a co-partner in the father's HUF or in the family HUF. So, would such an illegitimate child also get a share? The Supreme Court gave a very balanced view. It says once legitimacy is conferred on such children of a void marriage by virtue of the Hindu Marriage Act, no distinction then arises between children who are born legally and children who are deemed to be legal. Then it's at par. They have a common playing field. All property of an intestate Hindu is to be divided amongst his class 1 legal heirs. Now, when I say that the child has become legal, then he is a class 1 legal heir. Then I don't distinguish between whether he is illegitimate or whether he was illegitimate. And when I say all property, it includes the father's share in the HUF, because property is very wide, including everything. Therefore, an illegitimate child is entitled to a share of his father's HUF. However, and this is the caveat which the Supreme Court added, he does not automatically, he does not ipso facto become a co-partner in the HUF. So such an illegitimate child would never become karta of his father's HUF. Such an illegitimate child would never become a co-partner entitled to claim a partition of his father's HUF. And the reason for this was that we can only allow him to claim a share in his parents' property, but we do not want him to encroach upon the rights of other co-partners of the HUF. We do not want him to encroach upon the rights of other children who are legal. Therefore, two conditions: the marriage should be valid under the Hindu Marriage Act. The child should be valid as per the Hindu Marriage Act. He would get a share in his father's HUF, but he does not become a co-partner. So that is the thin line which the 3-member Supreme Court came out with a couple of months ago. This was a controversy which has been raging for the last 10 years, and finally we have a finality on this. There is talk that under the Uniform Civil Code all of this will change, but how would it happen, when it would happen, is something in the realm of speculation. So as of now, this is how the law stands. Now, what happens when a person dies intestate? You would then need, that is the legal heirs would then need letters of administration from a court of law. The letters of administration would be proof that the person has died intestate, and after him these are the legal heirs as per class 1, class 2, or in case of a lady as per the schedule laid down. They would have to apply, so if it's in the city of Mumbai, they would have to apply to the Bombay High Court along with the death certificate as proof of death. List of legal heirs as per the Hindu Succession Act, depending upon whether the deceased was male or female. Likely amount of estates or asset of the deceased. They make an application statement through a lawyer. The court would then invite a public notice inviting objections or claims that we intend to grant a letter of administration to these legal heirs. Anybody having objection or contrary claims, please approach the court within a certain number of days. If there are objections, the persons making a petition need to contest. If there are no objections, the court would grant a letter of administration. Once a letter of administration is granted, the legal heirs could go to the property registrar, get the record of rights mutilated. They could go to a cooperative society, get the share certificate changed, go to banks, depositories, and other asset classes where they can then become the legal owners. So what probate is to a will, letter of administration is to no will. That's the hierarchy when you look at both of these important letters of administration and probate. There is also a third category known as succession certificate. Succession certificate is the same letter of administration, but it only applies to shares, securities, mutual funds, and bank. You cannot use a succession certificate for immovable property or flat in a cooperative society. So if there is a deceased who died without any immovable property, you could go in for a succession certificate, but otherwise a letter of administration is definitely advisable. HUF, as I mentioned, we as chartered accountants are quite familiar with the Hindu undivided family, but we here are looking at it from the legal perspective. What is an HUF? It consists of a lineal male descendancy from a common ancestor. So there is one common ancestor who sets up the HUF, and then his sons, now daughters, wives of the sons, are all, and children thereof, are all treated as part of the HUF. A son is not a must for an HUF. A common myth prevalent in our Indian banking circles that if there is only a daughter, you cannot have an HUF. Nothing could be farther from the truth. You do not need a son for an HUF. A male, his wife and his daughter also create an HUF. In fact, HUF is created when a person marries as per Hindu law. But for it to become a taxable entity, you need 2 or more co-partners. And a wife is never a co-partner, wife is a member. She is a second grade constituent of the HUF. First would be the co-partner. So a husband and wife would have only one co-partner. Only when a child is born, whether a girl or a boy, would an HUF come into play from an income tax perspective. Can a lady have an HUF? So can you have a Mrs. Shah HUF? Answer is no. Our Hindu law, as I mentioned, is yet predominantly male dominated. So therefore, only a male could have an HUF. A question which arises that sometime in September 2005, to be precise, 9 September 2005, the law was changed to allow daughters to be co-partners in the father's HUF, and I'll come to that. So why not a daughter's HUF? But in spite of that, it was only a one-dimensional modification. They did not change everything. Ladies cannot have an HUF. They could be a member in their husband's HUF. They could be a co-partner in the father's HUF. They could even be a karta in the father's HUF, and we look at that. But she cannot have an HUF in her own name. Something which needs to change urgently and hopefully will change with time to come. Daughters' rights. After 9 September 2005, a very important watershed amendment, a daughter of a co-partner shall by birth become a co-partner in her own rights as a son, have the same rights in the HUF as a son, be subject to the same liabilities in HUF property, and have a share equal to a son. So, full parity in the father's HUF for daughters and sons. There is no difference between the two. This is only in father's HUF, not in husband's HUF. In husband's HUF, she is yet a member. Very strange that if a girl marries and goes on to her husband's house, she yet does not get full co-partnery rights in the husband's HUF. But the family which she might have left years ago, she yet continues as a co-partner. I don't understand why they did not extend the same benefits even to husband's HUF, but that's the law which we have to live with. Some unanswered questions which the law did not address. Do daughters' children automatically become co-partner in their maternal grandfather's HUF like sons' children? I would think yes, because if you are extending same parity to a sister and a brother, then if the brother's children become co-partners in their dada's HUF, why should not the daughter's children? I would think yes. Would her husband become a member in father-in-law's HUF? This is a tricky one. It's a banana peel question. Son's wife becomes a member. So then if I look at parity, then daughter's husband also should become a member. But he does not become a co-partner. He becomes only a member. Now, this amendment, as is wont, was only a 2-liner amendment. And it left a horse of confusion amongst the country. Does it apply to daughters born after 9 September 2005? Does it apply to daughters married after that date? Does it apply to all daughters married and unmarried but living on that date? Is the amendment prospective or retrospective? What happens if the daughter was born prior to the Hindu Succession Act 1956? Or a new twist which was introduced by some of the Supreme Court decisions, and very strange, Does it only apply to those daughters whose fathers are also alive on 9 September 2005? That is what in Dannamma versus Amar the Supreme Court came out with. Both daughter-father combo, this was like a McDonald's Happy Meal. Both combos should be alive on that day, then only you get this benefit of the amendment. And again, this caused a lot of confusion. Finally, better sense prevailed. In 2020, we had a very landmark Supreme Court decision in Vinita Sharma versus Rakesh Sharma, which has addressed all these questions. Daughters have an equal right with sons in the father's HUF. Daughter's father need not be alive on 9 September 2005. It does not say living daughter of living father. It says living daughter of a co-partner. Co-partner might have died many moons ago. It's fine. HUF must exist on that day. That's very important. If the HUF was already partitioned prior to 9 September 2005, then nothing to the daughter. Daughter must be alive. If she has passed away, her children cannot claim a share in the grandfather's HUF. So, two conditions: daughter alive, HUF alive. And if the HUF is partitioned by an oral partition, that would not be recognized as a partition, because the Supreme Court said there are many unscrupulous families which, to deprive the daughter of the right, might say there was an oral partition, HUF is no longer in existence. It must be by virtue of a registered HUF partition deed that the HUF has been done away with. In that case, the daughter would not have a right, or if the daughter was not alive, she would not have a right. In all other circumstances, whether daughter was married, unmarried, whenever born, even born prior to 1956, even if father is not alive, she would become a co-partner in her father's HUF. Can a daughter now become a karta in her father's HUF? So Supreme Court in a very important decision said co-partnery is a must for kartaship, and because daughters are never karta, she could never become daughters are never co-partner, she could never become a karta. That has now changed. She is a co-partner. Hence, if the daughter is the eldest child, she would become the karta. That's the decision of the Delhi High Court in Sujata Sharma versus Manu Sharma, where there were 7 children and the eldest was a daughter. She was treated as the karta because she was the eldest. If she decides not to be karta, that is, she voluntarily relinquishes, then after her brother or anybody else could become karta. But otherwise, in the order of priority, it's the daughter, if she is the eldest child, who would become the co-partner karta.
Excuse me.
Yeah.
What is the difference between member and co-partner?
Yeah, we'll come to that. Okay. Can wife now be a karta in her husband's HUF? Answer is no, because as I mentioned, only a daughter is a co-partner in her father's HUF, but not a co-partner in her husband's HUF. There she is only a member. And what then is the difference between the two? So a co-partner is one who can claim partition, whereas member is one who cannot claim partition. So as a co-partner in your father's HUF, a daughter can say, I want to partition this HUF and I want it to be divided amongst us, whereas a wife cannot do it in her husband's HUF. That is the only difference between a co-partner and a member, and therefore only co-partners can be karta, because it's only the co-partner who has this important right to wind up the HUF. Now look at a scenario where there are 3 members in a family, a very nuclear family which is very common in today's day and age. Father, mother and a child, son or daughter. Father dies unfortunately while the child is a minor. Wife is a member, she cannot be karta. Child is a minor, he or she cannot be karta. In that case, who would be karta? Here Supreme Court came out with a Vaya Media in Shreya Vidyarthi's case. They said wife could be a manager karta till the child becomes of 18 years of age, and after that the child would become the karta. So if there is no one, the mother could become a manager guardian karta, but otherwise it is always the father and after him the children. What is an partition? Again, yeah. Sorry? No. Because she is not the full karta. Only the full karta. She is only a guardian. She has no right to claim partition in her father's husband's HUF. So she would be the karta. But provided she is 18 years and above. Partition means defining the shares of the co-partners. You are dividing what was joint. Hindu undivided family is a joint family. You are now doing with the jointness and making it separate. Would actual physical division be a must? Means must you give this property here and that property there? As long as you can unequivocally show that there is an intention to separate, this is only part of the process. But otherwise, it's always better to physically divide amongst the family members. Now, very important, our Income Tax Act does not recognize partial partition. Now, what do you mean by partial partition? Say there are 7 members in a family, 5 decide to remain joint, 2 want to separate out. That's called partial qua the family members. There are 15 properties in a family, 10 decide to remain within the group and only 5 are separated out. That's partial partition as to assets, or partial as to some assets and partial as to some members. Is that legally valid? Answer is yes. Under Hindu law, partial partition is yet valid. But income tax has a caveat. We will not recognize partial partition. You may do partial partition, but for taxation, the HUF will continue to remain joint. The assets which go out will continue to be treated as property of the HUF. The members which go out will not be treated as taxable in their own right. So if tax is not an issue, many times partial partition is yet done. When only one member of the group has a problem, then you partition that group out and you continue as if the HUF has continued for the rest of the thing. How do you partition? Oral partition. So members could come together and decide that we have decided to partition, but there's no evidence of the same other than orally confirming the same. By a legal suit, if matters have gone very bad and they're not on talking terms, you need to file a legal suit, or an arbitration award. That's what is most common, where members decide to refer it to a common family friend or a member who can then balance both sides and come out with an arbitration award. Or a deed of partition. If everybody agrees, then you can have a deed of partition where you then decide to divide the assets amongst a certain proportion. All of these could be for partial as well as for total partition. Who can demand a partition? Any co-partner can demand partition. Can a wife demand partition? Is a wife a co-partner or a member of the HUF? Wife is always a member, never a co-partner. Even as a guardian, she would never be a co-partner. Therefore, she can never claim partition during her husband's lifetime. After Hindu Succession Amendment Act, is there any change qua a wife? Can she say that now I am at par? No, it only changes the daughter's rights, does not change the wife's rights. So again, she cannot. But a wife, that is a mother, is allotted a share on partition equal to what is allotted to the child. So if the son gets 25%, the mother will also get 25%. That is a shelter provided that in her husband's HUF, she should at least get what is equal to what the child is getting. Thus, she cannot be totally done away with. She cannot ask for it, but if anybody asks for it, she will get a share equal to what the son gets. And I believe now that daughters are at par with sons. If there are no sons, she'll get a share equal to what the daughter gets. Can daughter claim partition of father's HUF? Of course, we looked at that because now she's a co-partner. What if she's already married? Does not matter whether she's married or unmarried or widowed. As long as she was alive on 9th September 2005, she can claim partition, and after her family members, if they become members in the, they become co-partners, could also claim a share of partition. Ancestral property. Now, this is something where there is a lot of confusion. Yeah. Yes, of course. You could even be of your grandfather's HUF. You could continue to be. Ancestral property is something inherited from 3 generations above of male lineage. Father, grandfather, great-grandfather. We've yet not had a case where we look at ancestral from a female lineage perspective, but I think it's only a matter of time before this issue hits the courts. Son, yeah. So stepchild would not be treated as a legal heir at all. So, no, nothing. He is not treated as a legal heir only. As we saw in the beginning, stepchild is not a legal heir, so he'll have no rights. Only illegitimate child would have, but nothing for the stepchild. Son, grandson and great-grandson of a Hindu all have an automatic right in ancestral property. They are deemed to be joint property. Now the common view is that ancestral property cannot be alienated. That is, a person cannot transfer what he got from ancestral property otherwise than to his children. That is, it has to go via the natural joint family rules. He cannot gift it or will it away to anyone. It can only pass by law to son, grandson, etc. This is the incorrect view. The correct view is ancestral property can be alienated, and there are various Supreme Court decisions on this. Section 8 of the Hindu Succession Act has modified all old customs and traditions. Property which a person gets on demise of his father would become his self-owned property. Once joint property is distributed, it ceases to be joint and becomes solely held. A very correct view was given by the Delhi High Court in Surinder Kumar's case. That is, after the enactment of the Hindu Succession Act, that is on and from August 1956, any person inheriting property from his parental ancestors, that is father, grandfather, etc., property is not ancestral in that person's hand and becomes self-occupied. If he has acquired it prior to 1956, then the ancestral property continues to be ancestral property and he cannot gift it or will it away to anyone other than to his son and grandson. So the touchstone is Hindu Succession Act, post and pre. Whatever was before is ancestral, whatever is after continues to remain separate and individual property and does not become ancestral. In spite of that, we have several cases going to the Supreme Court every few months, and many cases we have Supreme Courts giving incorrect views, not looking at the earlier decision. So this is something which there is going to be confusion, keep going forward. Notional partition. Now when a person, that is a co-partner, dies, how do you determine his share or now her share? So on death of a co-partner, a notional partition of the HUF takes place just prior to his death to determine what is his or her share, which will go either by intestate succession or under his or her will. So assume there are 10 co-partners in an HUF and one of them dies. Just before his death, it would be determined total divided by 10. So he had a 1/10 share. Now that 1/10 share, if he in the will says my share in the HUF would go to my son, 1/10 would go to his son, and if he has not made a will, then under Hindu Succession Act, 1/10 would go to class 1, class 2, agnate, cognate, as the case may be. That is also been laid down by the Supreme Court in Arumugam's decision. So do a notional partition just a day prior to the demise of the co-partner. So she is not a co-partner, she is only a member. Most common question, now that you've looked at what happens if you don't do estate planning, is that I have 2 children who will inherit everything after me. Why should I make a will? Why should I make a trust? I don't want to do anything. Always remember that the children will inherit as joint owners. Ultimately, property will pass as per law. So if there is no will, all class 1 legal heirs would have an equal share in all assets. So what will happen is there would be cross ownership in all the assets. Now if the children want to disentangle the assets, there will be an incidence of stamp duty, there may be an incidence of income tax, and if they don't agree, there would be litigation, there would be bad blood. So do you want to leave behind a legacy of litigation and costs, or do you want to streamline everything and make it a seamless succession? Is the choice which everybody needs to take. And therefore, plan you must. Now we look at what are the estate planning options. So it's like a bottom of the pyramid approach, where at the bottom you have joint holding and nomination, which could be done during lifetime, but which take effect after death. Then a more sophisticated option of wills, which again take effect after death. And the most sophisticated option is a trust, which could be done and which takes effect in one's lifetime and which totally takes care of all disputes which may be there under the will option. Let's look at joint holding and nomination, quite popular amongst most of us, but we'll look at a few niceties which one comes across. You could have this concept for flats, bank accounts, fixed deposit receipts, demat, shares, mutual fund, PPF. Joint holder can be either or survivor, that is he can transact along with the first holder during his lifetime, or former or survivor, where he can transact only after the first holder dies. Either case, the joint holder becomes the owner on the death of the first holder. However, very important to remember, a joint holder is never the beneficial owner. Ultimately, the joint holder will be bound to hand it over to the person as per the Hindu Succession Act or as per the will. So assume a person has made his brother joint holder in a bank account along with himself, and he dies without a will. It will go ultimately to the class 1 legal heirs, that is his wife and children. The brother will be duty bound to hand over the bank account to the deceased wife and child, and if he has used up the money as a legal owner, then he has to make good the same. So it's only a stopgap arrangement, never the ultimate arrangement. Nomination, on the other hand, is entitled to receive assets on the death of a person, same as a joint holder, only a stopgap arrangement till the estate is executed and bequests made. Nomination, unlike joint holder, can be in favor of a minor also, puts nominees in the deceased shoes and clothes him with exclusive right to assets. So you are just stepping into, society wants a face to deal with when the person dies, therefore the nominee. What overrides what? Will or intestate succession will always prevail over nomination, never vice versa. Nominee can never say, I am the legal owner. You are always a stopgap arrangement. Beneficial ownership goes as per the will or as per the intestate succession. We have this very famous decision of the Supreme Court in Indrani Vahi, and this has caused a lot of confusion amongst flats in cooperative society. I've seen several cases floating around on University of WhatsApp where they say that nominee will become the legal owner in a flat, managing committee must transfer to nominee and ask no questions. Answer is yes, to a point. When a person dies, who is the nominee? The cooperative society managing committee has to transfer the flat in the name of that nominee. It does not have to ask why him or why her, but ultimately the flat will go as per the will, or the flat will go as per the Hindu Succession or Indian Succession Act intestate succession law. So it's not that the nominee will override the will, it is just that immediately the nominee will become the legal owner. So if you look at this decision, this was of a case in Kolkata, where a father living in a cooperative society with his married son, wife, made his married daughter the nominee. After he died, the married daughter went to the society and said, I am the nominee, transfer the flat in my favor. Her mother and brother said, when we took care of the father, when he was living with her, how did he make the daughter the nominee? And the society agreed with the family saying, yes, we are not going to transfer it to you. Matter went all the way to the Supreme Court, and the Supreme Court said, as managing committee, you have no locus standi to question the nomination. He may have made it in favor of XYZ. Your job is to only see, is the nomination form valid? Was it signed? Was it properly deposited with the society? If yes, you have to transfer it immediately to the daughter. Ultimately, a court will decide who gets the flat, and because the father died without a will and he was a Hindu, there would be a class 1 succession. The wife, the son and the daughter each would get a 1/3 share, but that is not for the society managing committee to decide. That is for the court to decide. Your job, transfer it. So to put the law in perspective, the managing committee needs to immediately transfer it to the nominee, but that is not the end of it. Ultimately, the flat goes as per the will or as per intestate succession.
So there will be two transfers then?
There will be two transfers then, yes. Then they will have to make good the money or the asset to the legal owner. And normally the society will not allow the nominee to sell it. Yes. So in Maharashtra Cooperative Society Act, after the amendment, there is a concept of a provisional membership which we have, which makes the nominee as a provisional member. But even today, most societies don't allow the nominee to sell it, because if he sells it and the legal heirs say, I don't want the money, I want the flat, then how is the society going to make good that? And even otherwise, when you go to buy a property, the buyer's advocate would always say, what is your legal right? Show me your title. A good lawyer would never allow you to buy it from a nominee, because that's fraught with danger. Nominee is only a trustee. True. He is not the beneficial. I think we'll look at such fact-based questions at the end. But here, if you have any clarifications, you can ask me. Otherwise, we'll take these at the end. Nomination in a company. This is a very interesting situation. In the Companies Act, both under the 1956 Act as well as the 2013 Act, it says shares vest in a nominee overriding any other law or will made by the deceased. So this kind of gives the impression that nomination overrides the will in the case of shares in a company, whether in physical form or in demat. This has caused a lot of confusion and a lot of controversy, and the matter has gone to several court decisions. Single bench of the Bombay High Court said nomination will prevail over the will, and therefore whoever you have made a nomination in favor of will become the legal and beneficial owner because of the specific wordings in the act. Another Bombay High Court single judge said no, this decision is wrong and it's not rendered after considering other decisions. Finally, a two-member judge decision said no, will prevail over nomination even in case of demat shares, even in case of physical shares, and the same position as other assets, nominee is at a lower level, will would be at a higher level. Hierarchy, how do you look at joint holder and nominee? First, joint holder. So if the person has made a joint ownership, he or she will get everything after the person dies away. If both the joint holders are not in existence, then the nominee comes into play as the legal owner. So generally you have a case where a husband making his wife the joint holder or vice versa in the bank account, and then they're making a nomination in favor of their child. So if husband dies, wife becomes joint holder. If both die, child becomes nominee. That's how you would look at it. But in both cases, joint holder and nominee are only legal owners. Beneficial ownership goes as per will or intestate succession. Now we look at a will. What is a will? It's my last wish. It's a legal declaration of a testator's intention. That's just hi-fi jargon. Simple, it's the last wish of a dying person. And speaks from the grave. That's another, if you want more dramatics, that when a person dies, a will only speak from the grave. So that means till I am alive, I could keep making a will every minute. There are people who, I have clients who make wills every 2-3 months. They keep changing their mind. I don't like him. I have a fight with my son. I don't like my daughter, whatever. They can keep changing wills. They can keep doing it as long as they like. There's no restriction. The last will, which was final prior to his or her death, would be the one which would lay down the succession pattern. Can be revoked n number of times, no limit on the number of revisions in a will. Who can make? Any major person, that is a person over 18 years of age, because only then you are treated as competent to contract in India. Male or female, no bar. Intoxicated person or one who does not understand what he is doing. So somebody who is in a substance abuse, or somebody who is so badly sedated, and this is especially true in the case of hospital patients. When they are so badly sedated, they don't know what they are doing or they don't know what they are signing, that will would not be treated as a valid will. A person who is deaf, dumb or blind definitely can make a will, provided they are aware of what they are signing or what they are putting their thumb impression on. What if somebody is ordinarily insane? Then during intervals of sanity, he or she can make a will. But how are you going to prove that when he made a will, he or she was not insane? You would need a psychiatrist or a neurophysician to verify that. Illiterate, definitely. There are many illiterate people who are owning valuable land and other properties. So they would have to put their thumb impression, but again, should be aware of what they are putting their thumb impression for. Very old people, terminally ill people, yes, provided they know and they are in a position to express their views. Lunatic cannot, because that person would never be sane. Person with Alzheimer's disease. Now this is becoming an important thing in today's day and age with Alzheimer's disease so prevalent. Such a person has no control over his faculties on a normal basis. Hence, very important to get it certified by a psychiatrist or a neurophysician that the person is in a mental state of mind. I would not go by an ordinary GP certification, because when it comes to a court of law, this has been one of the main planks of the opposition, that is mental faculties were not all right. Parkinson's disease, also a brain disorder, but more a motor disorder. So that is treated as okay, and Bombay High Court has said a person with Parkinson's can make a valid will. That is not a bar to making a valid will. How do you make a will? Do you need a stamp paper? Yes, if you are watching movies. No, in the normal day and age. You could just write it on this receipt which they gave me. I could make a will behind this. It could be on the back of a tissue paper. In Boston, some of the largest wills were made in a coffee shop on the back of a tissue paper in a cafe, and 2 people witnessed it. That was treated as a valid will. You could do it in your own handwriting. Oral wills only allowed for Muslims under Sharia law and for soldiers, because soldiers are on battlefield, and in that precarious situation, if they want to make a will, they are allowed to have a holographic will, which is an oral will. Signature or thumb mark of the testator, very important. He needs to sign, or he needs to put the thumb mark. Do you need to sign on each page? No. Is it advisable? Definitely. 2 witnesses to attest the signature of the testator. We'll come to that in a while. Appoint executors. Executors are persons who put the will into motion, because the will takes effect only when a person dies. So who will put the will into execution is the executor. Date the will. Most important, a will without a date would be treated as invalid, because you don't know whether it's the last prevailing will. Designate the legatees and beneficiaries. Decide who gets what. You may have a one-liner, I leave everything to my wife, or I leave everything to my husband, but you have nevertheless designated, or you lay down all your assets and you say this goes here, this goes there. Only assets owned beneficially. Do not include where you are a joint holder or a nominee. So if you are a joint holder or nominee in somebody's assets, don't include that in your will, because that's not an asset which you are beneficially owning. So normally you cannot will away a share in a partnership firm. It would go as per the partnership deed, and the deed may provide that in his place so and so will be added as a partner, but otherwise share in a partnership firm, because it's not a separate legal entity. Share in an LLP can be willed, but share in a partnership firm, normally you can't. Who can be a beneficiary? Anyone, relative, friend, employee, servant, chartered accountant, lawyer. Can it be a stranger to the testator? Definitely. We all know of famous R.S. Lodha decision where a chartered accountant became the beneficiary under Mrs. Priyamada Birla's will. So anybody under the sun could be a beneficiary in the will. Can pets be made a legatee under a will? Yes, but then you would have problems because they cannot own property. And one of the conditions to becoming a legatee under the Indian Succession Act is the person must be capable of owning property. How would a pet own a property? How would he have a bank account? How would we have a PAN? How would he have an Aadhaar card? So all these would be questions. Therefore, have a trust set up for pets. So you have a trust where there are 2 trustees. Put all the assets in the trust, and the beneficiaries of the trust could be pets. If you look at, there's a Netflix series on Gunther 3, a famous dog who was left $80 million by his master. And he is the world's richest dog. He has his own condo in Hawaii, and he's really got the work. So do check this out. I had a client who wanted to put 5 crores in trust for their 2 golden retriever dogs. So, you know, they say it's a dog's life, but sometimes becoming a dog could be a better case than, you know. So don't just leave it in name of the dog or the cat, but have a trust. That would be a better option. Who can be an executor? Executor is the person who puts the will into motion, like the managing director or the board of directors in a company. Here is the person who puts the will into motion. How do you select an executor? Should be someone close to the testator, so that people who he is close to, and also I suggest close to the beneficiary, so that they would listen to him. And advisable that he is younger. Don't select someone who is older than you, because you may have a case where he may pass away before you, and then you are left without an executor. What happens if you don't have an executor, or if the executor has passed away, is that then the beneficiaries would need to go to court, and the court would appoint an administrator, which would be another mess. So try and avoid that. Consider having alternate executors. What if something happens to him, or he is not in a position to act? Then have an alternate executor. Yeah, we'll just come to that. What are his duties? Pay off the debts, and then divide amongst what is laid down. Who should be witnesses? Now, what is the role of a witness? Witness is a person who will witness the testator signing in their presence. They must receive a personal acknowledgement of the testator's signature. So they must see the testator sign. Do they need to know the contents of the will? This is a very important question which I'm often asked. Answer is a resounding no. They do not need to know what is in the will, who gets what. They only need to see that person sign. Can witness also be a beneficiary? Answer is yes and no. If the person making the will is a Hindu, Jain, a Buddhist or a Sikh, then yes, witness can be beneficiary. But if the person making the will is anybody else, like a Christian, a Parsi or a Jewish person, then no, witness cannot be a beneficiary. This is because the Indian Succession Act has done away with certain sections for Hindus. Now, this is one of the sections which does not apply to Hindus. Therefore, for a Christian, witness should not be a beneficiary. Is it advisable even for Hindus? I would say no. Why would you want to have a situation of a conflict of interest? It's very easy to get a witness. So have a separate person for witness and for beneficiary. Can witness also be executor? Yes. There is no bar for any community. What if testamentary capacity is doubtful? Means if there is a doubt, a person is very old. So 3 years ago in COVID, I had a situation where a 94-year-old gentleman wanted to make a will. Very fit, very mentally active. How do you prove that at 94, in a pandemic situation, he has his right faculties? So I said, get me a testamentary certificate of your mental faculties, but not from your regular doctor. I wanted it from a neurophysician. So he went to a doctor who put him through a series of tests, not medical tests, but he asked him all sorts of questions, like name 5 things with the letter P, and which is this color, and after that what comes. It was quite a difficult test, and I would think I would fail if I were to go for that test. He passed it with flying colors. The doctor gave the paper, the question paper and his certificate, and we annexed all of that to the will. Unfortunately, the gentleman died sometime later, and this matter is in probate, and as luck would have it, his family members have claimed non-capacity of mental faculties, and this has come to the rescue of the people who have asked for it. That he was totally sound and totally sane, because look at the kind of questions probed, look at the doctor's certificate, and look at the answers given by him. So if there is any doubt, go the extra mile. Do not just rely on a normal physician certificate. You must go and give him an exact certificate from a neurophysician or a psychiatrist. Who could be a general witness? Anyone. But I would think avoid people who you may find difficult to get later on, because ultimately the witness may be examined. So if I have people who have looked at drivers and watchmen. Now what if they leave your employment and they go away somewhere? Or if they say that I don't know what I signed, then it could be a problem. So have people of repute, have people of some standing. Many times chartered accountants are asked upon to be witness. Yes, please, you can become witness. There's no harm as of now. Unless PMLA gets amended for that also, then we'll have a problem going forth. But as of today, there's no problem in becoming a witness to a will. Doctor's certificate, I already dealt with. Should not be more than a few days older than the will. 1-year-old doctor's certificate, is it valid? Obviously no. So, these are sort of questions which I have, that last time I made a will 1 year ago, I had it. Do I need to again go? Answer is yes, please do. In fact, when you go for registration of the will, if you decide to go, the registrar says not more than 2 weeks. He has kept a time limit of 2 weeks. Now that is nowhere in any of the laws, but that's his own internal instructions, that I will not accept a doctor's certificate which is more than 2 weeks old. Top 10 myths. Wills are full of myths. So I've got some myth busters. Will must be on a stamp paper. No, it could be written on a plain paper. There is a legal format for a will. No, there is no format. But I would prefer that you make it in a certain manner, because ultimately the will is a piece of paper which is going to stand scrutiny before the court. So you better have everything in it. Will once made cannot be changed or altered. Absolutely no. Will is effective during a person's lifetime. Absolutely no. Will cannot exclude near and dear relatives. It can, but if you are for better safety, give reasons why. so that the court will know that why you have excluded your child or why you have excluded your brother. It will help in showing the reasons why. Will need not be dated. We've dealt with that. Nomination prevails over the will. Always will over nomination. Married women cannot make a will. They can make a will. No witnesses are required. 2 witnesses are a must. And the last one, marriage revokes a will. Now, this is both a myth and a reality. For Hindus, a marriage does not revoke a will. So, a person who makes a will when he or she was a bachelor or unmarried can continue with the same will even after marriage. But in case of a Christian, a Parsi or any other community, on marriage, the old will revokes and is lapses. Unless he does not make a new will, it would be treated as if he or she died without making a valid will. So you need to look at who is making the will and what is the situation, and then accordingly whether you need a new will post-marriage. Yeah? Sorry? Yeah, any language, as long as it's in a proper, understandable. With due respect to Dr. Dalvie, doctor's prescription language will not work. So, yeah. Sorry, come again. So that's something under the Special Marriage Act. We have a slide on that. We'll deal with that at the end. Yep. Yes, of course. You can have a conditional will that if you will marry as per the agreement of the family, then only you will get. There are what is known as conditions precedent, that is conditions to be fulfilled before getting the estate, or conditions subsequent, that is if you will get the estate today, but if you don't comply, it will be taken back. You can have a conditional. Yes. I have a slide on probate, we'll look at that. So let's just move on, and then we'll definitely look at questions at the end. Joint wills, jointly made by 2 persons, husband and wife. Couple prepares 1 will for distribution of joint and separate properties. On death of husband, all properties go to wife, and on death of wife, all properties go to husband. And they also lay down that if both of us were to die, what would be the scenario? Mutual wills, now this is something which is not very common, but is becoming popular, where the condition for making the will is you doing what I say and I doing what you say. So when does this come in relevant? So it says I give everything to my wife on the condition that she gives everything to me, and both of us agree that after us it will go to our nephew. Now when is a mutual will advisable? This is done when there is a fear that after one of the spouses passes away, there would be a remarriage, and the wife may then change the will, or the husband may then change the will and give the estate to somebody outside of the family. So then there is what is known as a mutual will, where you cannot unilaterally change it. Both the spouses should be alive to change the mutual will. So if one dies, will is locked and has to go as per that. Court will not allow you to change it even though you are alive. So generally a separate will is preferred because different people may have different conditions, different thought processes. You may want to give everything to charity, your wife may want to give everything to the children, etc., etc. But if a situation of mutual will is preferred, then you can have a mutual will scenario where you lock it the moment one of the spouses passes away. A third type of a will would be a mirror will, which are just mirror images of my will is a mirror image of my wife's and vice versa. Special issues, people who are physically, visually, mentally challenged, autistic, schizophrenic, mention the exact nature of disability, provide for a guardian or a caretaker for such a child, and again have a trust under a will, because that child or that person would not be in a capacity to own property. So you should have a property trust for that person. And life interest beneficiary. This again is very common, where a spouse says, I gift the property to my wife. This is a conditional case. But she only has a right to reside. The moment she passes away, my child will become the owner. So she is only a conditional life interest beneficiary. She can do nothing with it in her lifetime. If you recall the case of the Supreme Court which we looked at in the beginning of the Gurudwara, it's similarly a life interest beneficiary case. Tenanted property, very important in Mumbai, in South Mumbai. Pagadi property. Can I make a will for a Pagadi property? Answer is no. Maharashtra Rent Control Act says that whenever there is a tenanted property, the family members of the deceased tenant residing with him at the time of death in the residential premises will automatically become tenants. And if it is a commercial property, then the family members who were in business with him will become tenants of the commercial property. And if no family members were residing with him or no family members were in business with him, the property reverts to the landlord. If the State Rent Control Act does not prohibit, it can be willed away. So if we are looking at Uttar Pradesh, if we are looking at Delhi, you can make a will for tenanted property. That's the Supreme Court's decision in Durga Prasad versus Narayan and Ram. What is family member under Maharashtra Rent Control Act? Not defined. But it would mean all those connected by blood relationship or marriage, married, unmarried, widowed daughters. HUF is not a family member. Although all the members of the HUF are family members, the HUF is not a family member. So this important case of Dr. Vasant Pratap Pandit. Here there was a person who was a tenant and his nephew was residing with him in the tenanted property. His son was abroad in America. The tenant died. Son made a claim to the tenanted property. Supreme Court said, were you residing with him at the time of death? No. Who was residing with him? The nephew, that is his brother's son. And the nephew was entitled to the tenanted premises in preference to the son. Could the person have made a will? Not in Maharashtra, but if in other conditions, he could, if it is in Delhi, UP, West Bengal, etc. Registration of wills. Now, this has again gained a lot of popularity. People go to the sub-registrar of assurances. So you can go to the sub-registrar in Borivali and register your will. Within 4 months from the execution time limit, not applicable, you can register it anytime. How do you register? You go there, you sign it in his presence, take 2 witnesses, give a doctor's certificate which is not then a few weeks old, and the registrar would then register it amongst his documents. What is the benefit of registration? You cannot say that the will is forged because it is now executed in favor of in front of a government official. It helps in establishing the genuineness of the testator, helps in proving mental capacity. Can a registered will be amended by an unregistered will? Or what if after registration I come out with an unregistered will? Is it valid? Yes. Is registration a must? No. Is it compulsory or does it help in granting a probate? Well, it does help little bit in granting a probate. Some people instead of registration go in for a notary also. That also helps to identify the person, and it does not, it helps to show that the will was not a forgery because in front of a notary it was executed. Probate. Now we had the question, is probate compulsory for a flat in a cooperative society? Answer in this forum here would be yes. What is a probate? Probate is a copy of a will certified by a court of law. This is final, nothing more needs to be done. There is no question of forgery, there is no question of undue influence. This is the ultimate will. Is probate compulsory? Again, you have a yes and no answer. Under the Indian Succession Act, all those cities which in 1925 were treated as princely courts, that is Mumbai, or rather Bombay, Calcutta and Madras. These 3 had a Governor General in 1925. So if you are an inhabitant of any of these 3 cities, probate is a must. If you are an inhabitant of any other city, but you have immovable property in these 3 cities, probate is a must. If you are an inhabitant of any other city with no immovable property in Mumbai, Kolkata or Chennai, probate is not a must. So somebody staying in Ahmedabad with a flat in Bombay, probate is a must. Somebody staying in Delhi with no property in Mumbai, Kolkata, Chennai, probate is not required. So that, and somebody staying in Mumbai, whether or not flat, whether or not immovable property, probate will always be a must. Many cooperative societies transfer without insisting on a probate. That is something they are doing extraneously. That is something which they are doing extra. Legally, they are required to obtain a probate for any transfer. If you don't obtain a probate, it may so happen that when your legal heirs go to sell the property, the buyer will insist on one, and that point of time it will become a hurdle for them to sell the property. How do you get a probate? In Bombay, you need to make an application to the Bombay High Court along with the payment of court fees, which fortunately is capped at 3% of the estate value, not exceeding 75,000 rupees. So as of now, we have a cap of 75,000. Someday this is definitely going to be removed, and then it will be 3% of the estate value, whatever it is. Executors and witness need to testify that they are the ones who are the executors and witness. They either need to go before a notary public or the court registrar. A general notice is invited from the public that such will has been put before us for probate. If you have any objections, please claim. If there are no objections, probate would be granted. If there are objections, probate needs to be contested. Usually, without objections, probate may be granted within a period of 6 months. Now there is entire e-filing of probate, so it's moving much faster. If it is contested, it's anybody's guess when the court battle will be over. What if you want to challenge? Yeah. That's what I just said, Kolkata, Chennai and Mumbai. If you want to challenge a will, that is you want to be one of the claimants under a will or probate, you need to file a suit. Court would issue notice to the defendant that there is a plaint against you. Defendant files a written statement. Plaintiff would then submit written evidence and court would deliver a verdict. Many times you hear in the papers that such and such person has filed a caveat before the Bombay High Court. Caveat means that when the probate petition will come up, it would not be granted without first giving a hearing to the person who has filed a caveat. So if I want to contest somebody's will, I can immediately go to Bombay High Court and say, whenever the probate comes, maybe today, maybe after 6 months, do not pass an order without giving me a hearing for it. So that's called filing a caveat. No. There's a recent decision of Justice Gautam Patel where a probate was filed after 33 years. And Justice Patel said probate is a continuing process, and there, because of the specific cases, he allowed it. But generally, I would think within 3 to 4 years, if you were to file a probate, it should be okay. I'm sorry, after he gets the probate, it's his property, then he could do whatever he wants. Arbitration clause. If there is a dispute in execution of wills, and one of the clauses is that you will refer it to arbitration of a close friend or family member, is it valid? Supreme Court has said no. It is merely an expression of the wish by testator that dispute should be settled by the arbitrator and nothing more. A unilateral declaration cannot constitute an arbitration agreement amongst all the members. If they decide to come together based on this clause, then yes, arbitration would be valid. But just because father has said that my sons will refer it to arbitration of the uncle, that is not valid, and it has no validity in the will. I have seen many wills which have an arbitration clause, but that would not prevail. New developments, video wills. Just as you are videotaping my talk, there are cases where the will is videotaped and the testator reads out the entire will. This proves beyond a doubt that A, he was mentally sound, B, it is not a forgery, and C, he knew what he was doing. And here the person can also explain, give reasons why he's excluding someone or giving more to someone. Very good development of video wills. Digital will for passwords to email, social media, online bank accounts, digital data. It could either be a part of the will or a separate digital will. If you don't lay down one, then Google, Facebook, Twitter, they all have separate rules as to intestate succession, as to how they would recognize a legal heir in case a person dies and there is no will. Organ donation, if you want, keep it separate from the will, because normally wills are opened after a person is cremated. Otherwise, then there would be no sanctity behind the organ donation rules. And the social customs will is something which is kind of an diktat to the family as to how the ceremonies and customs should be laid down after a person passes away. Cross-border wills. With LRS, we have many people owning immovable property, securities and other assets abroad. What happens to these assets when a person dies? Should you have one holistic will for all global assets? I would think no. Have a separate will for each country. Follow the laws of each country when you are making the will for that country. For instance, if you have assets in Dubai, one of the favorite places for Indians to own property, have a DIFC registered will, because then Sharia law will not apply. Otherwise, Sharia Islamic law will apply and decide who can get what. So always a good idea for immovable property in Dubai to have a Sharia law, the anti-Sharia law will, that is called a DIFC registered will. For Americas and assets, pay heed to US federal and estate duty, which could be as high as 50%. And probate fees vary as per state by state. So California levies the highest probate fees, but if you go to Texas or Florida, it has no probate fees. So you need to make your will keeping these factors in mind. UK has estate duty at 40%, but there is an exemption for one residential house in London or UK. So consider these factors very clearly when making a global will. Otherwise, you could leave behind a lot of estate duty and taxes for the beneficiaries. Reverse, if there is an NRI, a PIO, or a foreigner who inherits Indian assets, then he can remit up to $1 million from India, but he must provide documentary evidence of the will, sale proceeds of assets, and other documents to evidence that he was the rightful owner, and then they would allow 1 million per financial year to be remitted. For excess, you could seek RBI permission. RBI used to grant it easily during COVID. Now it has become tougher to get this permission. No. That's a very interesting question coming from Dr. Saab. That is TCS applicable? No, answer is no, because it is only on LRS. What you invest under the $250,000, TCS is. Or I would put it, till today it is not. They have not yet become wiser that it should also apply here. Private trusts, why would you want to have a trust? Now a trust is useful if the beneficiary is a minor, is useful if you have people as pets, beneficiaries as pets, or you have mentally, physically challenged people who cannot take care of their own properties, then a trust would be a very good vehicle to provide for. Complete control during lifetime. So you can set up a trust in your lifetime, be in charge, and after that the deed would provide what you want and lay down the succession pattern. No probate required like in case of will. Very big benefit. You are doing away with the main cause of dispute, that is the probate petition, because you are laying everything in your lifetime. Unlike a will which speaks from the grave, trust is set up in your lifetime. Reduce succession dispute, and if and when estate duty does come, which I think is a matter of when rather than whether, we will have a shelter against estate duty because it is outside the estate of the person, provided it's an irrevocable discretionary trust. So if you look at a comparison matrix, will takes effect immediately trust takes effect immediately, whereas will take effect only on death. Probate dispute litigation, part and parcel of will, not so in the case of a trust. Control after death, not possible in the will. Trust, you could have the full succession, trustees laid down. Estate duty saving possibility, not in the case of a will, is so in the case of a trust. And wealth planning for minor beneficiaries and handicapped relatives possible under a trust, not under a will. What is a trust? Trust would be a private trust, not a charity commissioner registered trust, not under the Maharashtra Public Trust Act, not a trust eligible for ATG benefits, not an income tax exempt trust, not a trust where you file Form 10BB and remember me after that. So this is not the dirty trust which we read about every day in the papers, where every day our chartered accountant brethren are getting sleepless nights. This is the nice one, which you fill it, shut it, and forget it. You just set it up and then it exists in perpetuity. You don't have to do anything. Can own property and investments, advisable for a host of people who you would want to provide for. 3 parties to the trust: settlor, person who settles; trustee, someone you trust in; and beneficiary, for whose benefit the whole thing is done. How do you set up a trust? The settlor and the trustee execute a deed, which is known as a trust deed. The settlor gives the corpus, that is the initial seed capital, to the trustee and says, take this and use it for the benefit of the beneficiary. In America, settlor is known as grantor, So in America, we would call it a grantor. In India, we would call it a settler. Both of them are the same. Deed remains the same. Trustee would be person whom you trust and who would then put the whole trust into motion. You could have two types of trust, specific and discretionary. Specific is where the shares are defined. Discretionary is where the shares are left open to the to the discretion of the trustee. So if you want to set up a trust for your two children and you don't want any disturbance between them, you would say, I want a specific trust 50-50 to my child. Each child will get 50%. But you want a trust which is discretionary, where the wife, child, grandchildren, everybody is a beneficiary. So there is a common pool. Who gets what from 0 to 100% could be left to the discretion of the trustees. It could be discretionary as to income, that is year on year, discretionary as to corpus, that is at the end, or discretionary as to both income and corpus. What can a trust own? Immovable property, land, building, flat, office. It can open a bank account in its own name. It can have a PAN in its own name. It cannot open a demat account in its trust name, but it can open a demat account in the name of the trustees linked to the PAN of the trust. So if you go to open a demat account for Apex Trust, the NSDL will not open a demat account in the name of Apex Trust, but it will open a demat account in the name of Trustee 1 and Trustee 2. But when you read the master client form, which you get when you open a demat account, it will say linked to demat account PAN Apex Trust. So that time you will come to know that this is not the personal demat account of the trustees, but it is the trust demat account. It can own units of mutual fund, it can own art, it can own every property. What it cannot do, it cannot make an LRS. It cannot make an outbound investment. It cannot own foreign assets because trusts are not recognized as an Indian entity under the FEMA regulations and rules. It is only a charitable trust which is registered, or a society which can own immovable property abroad or which can own foreign assets abroad. Private trusts do not have that benefit. Yeah. Sorry. Yes, they can. If you want to transfer property to a trust, you need a gift deed for settling land, building, flat, bungalow on a trust. Stamp duty on a gift deed would be applicable. So in Maharashtra, it would be 6% when you gift any property to a trust. Movable property, issue a check or an RTGS in favor of a trust. Shares, transfer of demat, off-market transfer in favor of a trust. Art and sculptures, endorse the certificate in favor of the trust. Can listed shares be transferred to a trust by the promoters? Answer is yes. If you were to look at the Nifty 50, I would say 60 to 70% of the companies, the shares of the promoters would be via a trust model. And entire promoter shareholding is now housed in a trust. So there are no succession issues, no problems of destabilizing of management after the person passes away, etc. But when the promoter will gift it to the trust, will it trigger the SEBI takeover code? Answer is yes, because the trust will be treated as a separate acquirer and the promoter is also a separate person. Both of them are persons acting in concert. And if it is more than 5% creeping acquisition limit per year, it would be treated as triggering the SEBI takeover code and the promoter would need to make an open offer. Hence, you need to apply for exemption to SEBI under Regulation 11 of the SEBI takeover regulations. SEBI has a specified format and it looks at certain prerequisites. Based on that, a whole-time member would give an exemption and then you could gift the shares to the trust and the trust would become the promoter going forth. So after the gift, the shareholding pattern will show promoter shareholding only in the name of the trust, nothing in the name of the personal individual promoters. If you make a gift, there is no capital gains on that. And 56.210 is not applicable provided the relatives are the beneficiaries of the settler. If there are anyone who is non-relative, then 56.210 would come into play. Can foreign beneficiaries be beneficiaries in an Indian trust? That is, what if there are Indian settlor and there are foreign beneficiaries? No express clarity in FEMA. It is a capital account transaction. It is akin to a gift by a resident to non-resident. Whether or not it requires an RBI permission is a matter of debate, is a matter of doubt, would depend upon various circumstances. In short, for the purposes of this discussion, I would say do consider a case clearly after seeing all pros and cons of making non-residents beneficiaries, and take a proper call on whether or not you need RBI permission. Most countries don't have an exchange control law similar to India. So if you're looking at a developing or a less developed country which has an exchange control law, then yes. So maybe Bangladesh. So if your beneficiary is located in Bangladesh, they have an exchange control law. So then you'd have to see the Bangladeshi law whether they could become a beneficiary in an Indian trust. But if you're looking at any of the G20 or other countries, they don't have such a law. They don't prohibit you from becoming beneficiary. They'll be more than happy. They'll get more estate duty. Yeah. No, it will get fastened to him when he passes away, not to this trust. Sorry? Because the person it's no longer his estate. It's gone away from him. So if it's an irrevocable discretionary trust, it's out of his balance sheet. He's gifted it away. Therefore, there's no estate duty. If it's a specific trust, then in the person who has a specific share, for him there would be estate duty. That's what I said. It's only when, not whether. Yeah. It will come. It's only a question of when. Yeah. Most developed nations, UK, US, the entire Scandic countries, Japan, everybody has estate duty. So I don't see us being insulated for long. Not yet. FEMA does not allow you to, a trust to become a beneficiary or an owner of trust. Even Gift City, FEMA is the starting point. So, well, structuring possibilities are always there. If I have an Indian LLP or an Indian company that owns, that is always possible. Directly in the name of the trust, you won't. Yeah. Directly, you cannot do indirect. This is not indirect. This is separate. Company would be a separate legal entity. So that is always possible. What happens? Nothing. His share depends on whether it's a discretionary trust or whether it's a specific trust. If it's a discretionary trust, he will cease to be a beneficiary. And it also depends on what the trust deed provides. If it's a specific trust, you may say it will go as per its will, or you may say that the others would now become beneficiaries. You have full flexibility in providing what you want. Therefore, the trust deed needs a lot of thought while drafting it. Many people I have seen just download a copy or copy something else and do it. It's not so simple. You need to apply your mind. There could be 101 myriad possibilities, and you're planning for the entire estate of a person. So think through all this, what you would want to do, and then ultimately take a call. Even then, I think it would depend on the deed, or if then nothing is mentioned, then if it's a discretionary trust, he should cease to be a beneficiary. But if it is specific, then his will apply. So it will go as per the will of the person. Sorry. Yeah, that's a problem you don't have, so you have to give all the beneficiaries' names. These are the whole genus which is there. We don't know who's going to get what, but I'm giving you all 5 of them. You give 5. Sorry. Yeah. How much time do we have, Nilesh bhai? 5-10 minutes. So, okay, let's try and capture that. So if a Hindu daughter marries a non-Hindu and converts her religion, so Hindu marrying a Muslim, would she still inherit her father's properties? Very important question. So you had the Caste Disabilities Removal Act of 1857. This was repealed in 2017. After its repeal, people started saying that means that post-conversion she will cease to be beneficiary of her father's estate. Answer is no. Who passed away? A Hindu passed away. Did the person who has converted passed away? Answer is no. The father passed away who was a Hindu. He died without making a will. Hindu Succession Act will apply. Daughter will remain a class 1 legal heir even though she has converted to Muslim. But when she passes away, it would go as per the Sharia law. Now, would she be part of father's HUF if her marriage is also registered under the Special Marriage Act? Now here it says that if a Hindu marries a non-Muslim and the marriage is registered under Special Marriage Act, the person ceases to be part of HUF of the father and ceases to be a Hindu. Therefore, she would not be part of the father's HUF, but she would be entitled to the share in the father's property. And yeah. Okay. Okay, fine. Coming to gifts, very popular between family members. What I'd like to touch upon is gifts are voluntary. They are without consideration. There is no income tax provided you fall within the purviews of 56(2)(10), and there is stamp duty, which you must bear in mind. Now, can you have a revocable gifts? This has been hitting the papers every day, and Chief Justice Dr. Chandrachud has very rightly reckoned it that when you fire a bullet, you cannot recall the bullet unless it was a conditional gift. So making a gift is like firing a bullet. There are cases where parents say, I gave the gift thinking my children will take care of me in old age. Now they're not taking care of me. I want my house back. Sorry. We have empathy for you is what the court says. We have sympathy for you, but we cannot give it back to you. But if the gift deed was conditional, that subject to you taking care of me, I'm giving you this house, then yes, the court will immediately give the house back to the parents. So make a conditional gift if you intend to make a gift during your lifetime. Don't just make it a generic gift. Otherwise, there's no way of pulling it back. Stamp duty, there's a stamp duty of 6% on immovable property in Maharashtra, 3% on movable property. Concessional stamp duty if you're making a gift to certain relatives. But if you're making a gift of residential property or agricultural property in Maharashtra to husband, wife, grandson, grandchild, father, mother, then the stamp duty is only 1%. So that's a very concessional duty. As I mentioned, no income tax provided 56(2)(10). Otherwise, the donee needs to pay tax on that. Release deed in case of co-ownership in immovable properties. When 2 or more persons are co-owners, one of them wants to get away. It's called a release deed. So he will release himself from the property. All legal heirs in a release deed would always be co-owners, whereas here what will happen is one will get away. Now why is a release deed popular? Because in Maharashtra, if it is ancestral property in which the beneficiaries are co-owners and one of them is going away, the stamp duty is only 500 rupees. Otherwise, the stamp duty is 6%. So depending upon whether or not it is ancestral, whether the releasees and the releasor are family members, you could have a very concessional stamp duty. Family settlement, when there is a dispute and you want to quell the disputes, you don't want to go to court, you want to arrive at an out-of-court settlement, you enter into family settlement saying this is mine, this is yours, and we decide to live happily ever after. Now family settlement does not attract income tax, does not attract 56(2)(10), can save stamp duty, does not attract registration. The only important thing is it should be bona fide and it should be for preservation of amity and goodwill, and it should be within family. Now what is family? It could even be the extended meaning, that is between cousins, could also be the purview of family settlement. It need not just be between real brothers or between real siblings. Courts generally lean in favor of upholding a family arrangement. Genuineness of family settlement is a must. Otherwise, income tax can question it, and now with GAR, it would definitely question it. Entire law on family settlement is case law based. There is no statute There's no codified law. It's all judge-based law. There have been some cases, but not more of them. It could be a touch and go scenario. Can married daughters be made a party to family arrangement? Definitely. There's no bar on married daughters becoming a party. A married Hindu lady can even execute a family settlement with her parental side heirs. Can companies be made a party to family settlement? Here, laws very dicey. Bombay High Court has said no. Supreme Court in Reliance's case asked a question whether the family settlement agreement claimed between the two brothers was signed by the MD as MD of the company. Was it put before the shareholders of the company? Was it party of a scheme of arrangement? Answer was no, and therefore they said it is not party to be relied on. So I think it would be very difficult to make companies a party to family settlement, but there have been some tribunal decisions like Sri Shivakumar of the Chennai tribunal where a person received certain shares from a company. The Chennai tribunal said you lift the corporate veil and say this is nothing but family settlement and therefore he should be entitled to no tax on receipt. I think that's a very, very aggressive decision by the court. I would generally feel companies should not be made a party to family settlement, but there have been some decisions in favor. Overall, largely against. Income tax, no capital gains, 56(2)(10) should not apply, but this has been a controversy. No stamp duty, as long as no new rights are created, it is only recording what was already the position. But this is a very thin line and therefore you need a very carefully drafted family settlement agreement. Practical experience, when you go to the registrar, he says stamp duty will be leviable. If you want to litigate, please go and file a case. I am not going to allow you to transfer one property to another without paying stamp duty. At worst, you pay stamp duty as if it's an HUF partition and at least give me 2%. That is what I'm saying is the practical experience. Legal provisions are very clear, no registration required at all. So one is your legal reality, which is the 35,000 feet, and one is your practical reality, which is ground reality. Here you will need to pay stamp duty on some basis or the other.
Stamp duty on a release deed. So for a joint property, is it better to do gift deed or release deed if one wants to release deed?
Sir, I'm very surprised to hear the level of questions from you because these are such high level questions that I'm truly surprised. Very interesting question. If there is a joint property, should I do a gift deed or a release deed? If it is ancestral property, that is, it has come from 3 levels up, release deed would definitely be the right instrument, provided I'm releasing in favor of family members, brother, sister, father, mother, spouse, grandchild. But if it is a release deed between 2 of us, we have no relation, then gift deed or release deed, I would be agnostic to it. But if it is ancestral and family, definitely release deed would be, because then you're doing away 500 rupees as opposed to 1%, 4%, 6%. But there have been several cases. The reason why I said the question was very interesting, there have been many Supreme Court cases on whether or not a deed is a gift deed or a release deed. It's a very thin line and it's based on several facts and circumstances. In fact, I'd written an article on it for BCA that it's a very thin touchstone whether or not a deed is gift deed or release deed. So do look at a release deed. Not very popular, but it definitely merits an attention. Yes. No, release deed, it will, then there would be some consideration, or even 56 would apply there also. Yeah. Hindu gains of learning. Now this is a very old act of 1930 and generally we would think, why are we looking at that? Now what happens if a person is educated out of joint family funds? So my education was funded out of joint family funds. Can the family now get up and say, look here, Anup, all what you are earning is because of the seed we planted. Therefore, the family also has a stake in your earnings. Family has a share in your properties and everything you own is joint family property. Answer is prior to 1930, yes. After 1930, all gains of learning of a co-partner are his exclusive and separate property, even if learning was funded by HUF fund. Income earned by him by his own skill, knowledge, learning solely belongs to him. HUF has no right, title or interest in the gains of learning of the co-partner. And gains of learning are very wide and they include any trade, industry, business, profession or vocation. Now I had a case a few months ago, and that's the reason why I included it here, where a person belonged to a very poor agricultural family in Andhra Pradesh, Telangana region. The father was a sugarcane worker. From his family funds, they strived very hard and they got his education done as an engineer. He went to the US and today he runs a multi-million-dollar IT company in US and in India. Now he had kept his younger brother and father as the nominees for his wealth in India, or the kind of trustees. Now he wants to do away with these people and he says, I want to manage, because there's a dispute between father, son and brother. So the father and his brother have taken plea that he got educated because of our joint funds. So this company which is there is joint family property and all of us have a stake in it. So that's where the Hindu Gains of Learning Act, I told them you look at that and that will come to your rescue. The matter went to the Andhra Pradesh High Court and the court ruled in favor of my client that yes, as per the Hindu Gains of Learning Act, even though you were educated by your father from joint family property, the shares you are owning in the US and Indian company are your own property and would not be treated as part of joint family funds. I'll wrap up quickly with what are the important ones. Yes, if there's a Hindu minor, you have the Hindu Minority and Guardianship Act. Now what this is relevant for is that the guardian, that is the natural guardian, is first the father and after him the mother. He or she can do everything which is reasonable and necessary for the minor's benefit. But if it is a transaction of sale of immobile property belonging to a minor, you need permission of the High Court of Bombay. So whenever you want to buy property for a minor, no permission. But if you want to sell property owned by a minor, you need High Court's permission. What if the father is the Karta of the HUF and one of the co-partners is a minor member? Would the HUF now need prior permission of the court to sell property? Supreme Court recently in NS Balaji's case has again reiterated no. Because HUF can function through the Karta, it is not the property of the minor which is being sold, it is property of the HUF which is being sold. And Karta can do all acts which are necessary and reasonable for the benefit of the HUF. Therefore, neither you need permission nor do you need to make the son or other other minors as consenting parties through their guardians. Hindu Adoption Act, post-adoption, the child severes all ties with his biological family. He would now become as if he was born in this family and he would be entitled to succeed to the estate of the father, that is the adoptive father, adoptive mother, would become a co-partner in the HUF and would cease to be all that in the biological family from the date of his adoption. You also have the concept of lineal ascendant and descendant, which we find in several statutes, including under section 56(2)(10). What does it mean? This is not defined anywhere in any law. It is a general judge-made law, which means people in a straight line, 3 levels up or 3 levels down, or more levels up and more levels down. Generally grandfather, father, son, or in the reverse, and even including females, grandmother, mother, daughter, or grandmother, mother, son. It is not restricted to males alone. What about adopted children? Would they be part of the lineal ascendancy, descendancy? Yes, because once adopted, he would be treated as if he is part of the biological child of the father who adopted him. Special Marriage Act was in a lot of prominence with the 5-member judge looking at it. If a Hindu marries a non-Hindu, Hindu Succession Act application ceases and Indian Succession Act takes over. That person ceases to be a member of the HUF and it changes the succession pattern both for the couple who married and any child born to them. But if it is a marriage between two Hindus, which is registered under SMA, and this is done when the marriage is registered abroad, for instance, you have destination weddings, which is then registered after Dubai, it is registered under Special Marriage Act, then you would both continue to remain Hindus. Now, this becomes very relevant in case of Muslims. You have many Muslims who register their marriage under the Indian Succession Act between two Muslims. So first the nikah is performed and then the marriage is registered. What is the benefit? Sharia law will cease to apply. After Sharia law ceases to apply, the couple can make a will, they can gift property in their lifetime, they can do anything which they want. It will be governed by the Indian Succession Act, and all restrictions under Sharia law will cease to apply. We looked at the case of conversion of religion, and that would not apply if the daughter changes religion, because the father has not changed religion. It would go as per the father's Hindu Succession Act. Thank you very much, friends, for a patient hearing. More questions, I'll be happy to take. Yeah. So nominee is also died, then it would be as if there is no one else, and the flat would then have to go to the beneficial owner. If there is no alternative nominee, then it would lie in limbo till the beneficial owner claims it. So it would go to the person to whom it has been gifted, and then it would be part of the equality alimony proceeding, and that will also go to both of them in equal proportion. But this is not going under gift tag. This is going under the marriage divorce proceeding. So there it is the joint property which will be gifted. You don't need love and affection for divorce. In fact, there, because there is no love and affection, it will be equally divided. 2% of the separated share. So you work out the largest share which is going out, and 2% after that on what is left behind. So if 3/4 goes away, on 1/4, 2%.
Just a minute before we take another question. All those who have started having food, I have just one small announcement to make. First of all, break is not started. Second, if at all you are having food, please, we are not allowed to have food here on chairs. So if at all you are having food, you have to do it in that area only. And we'll take next 3 questions and then we break.
Sorry? Statutory nomination, there's nothing statutory, it's optional whether you want to nominate. That's why CPE has been writing to everybody, please nominate, please nominate. If you don't want to nominate, you say I want to opt out. But there's no statutory, it cannot be forced upon anyone. I'm sorry, can you just speak louder? Stamp duty on what? What? On gift? Gift is 6% if you want to gift. Within family, it is 4%. But if to concessional for residential property for 6 relatives, it is 1%. 6, 4 or 1. Movable is 3%. Anything which is not immovable, so flat, building, land, office, that all is immovable property. Other than that is movable property. Depends if it's ancestral. If it is ancestral, there is no. Then there would be full stamp duty, 6%. Yes, ma'am.
Can you release this given by a son who is staying abroad?
Yeah, of course. Of course.
Sir, when a HUF is being partitioned by the Karta, can he go about doing it, giving different shares to different persons? And can that be challenged? And how do you
Yes.
ensure it is not challenged?
So unequal partition is possible only if all the co-partners agree to it. So therefore you should have a partition deed where everybody agrees to it. If they don't agree, you can't do that. Then they would have to go to court and the entire partition is at hold.
Sir, intestate succession, house property getting transferred to the nominee, and then the property going under redevelopment. How would that case be handled?
So he will continue to be legal owner, and everything, the taxation, everything will be in his name. He will continue to be the owner of the flat which comes to him. But ultimately, whenever the will or the legal succession takes place, he will have to give it to them. So he continues everything. He continues to be the new owner for the extra premises which you get in the redevelopment, all of that. Why 31st January? That is only for shares. That is not for redevelopment of property. That's only for shares. That's grandfathering is only for shares. So you just look at the BSc NSC quote as on 31st January 2018, but not applicable for immovable property.
HUF, let's say 5 person are there, son, daughter, whatever, and normally balances transfer to X to Y, Y to X, X to Y, Y to X, and there is no dispute. So at ultimate level, it should be treated as a gift between the partners, or any registered or any documentation is required. If there is no objection, nothing.
So you should, when you partition the HUF, you should record all of this in the deed. Always better.
Suppose there is no partition, Karta is whole and soul and he is doing in consensus with everyone.
Then it could be a loan or a gift, depending on whether they have to repay it back or not.
All right. If a dispute arises, then only. Thank you.
No, if it is immovable property gift deed, then yes. If it is movable, then you don't need a deed only. You could just hand over, like if I want to gift this phone, I could just give it and it's a gift. But if I make a gift for immovable property, it's a must. For movable, it's optional.
So last question. In the society, normally this problem everyone is facing, secretary or whoever may be. If the person who has died, he has not made his will, but all the legal holders write it out that yes, we don't have objection, you can give it to this person, then also legally the society is allowed or they are not allowed to transfer the property?
They correctly should ask for succession certificate, letters of administration. But most societies, based on the family members' knowledge, etc., are giving. There is no legality preventing them from doing it, but I think the better course would be to ask for a letter of administration.
Manar sir.
Is HUF allowed to transfer money to members on occasions like Diwali and all that? Normally,
So, Karta can make gifts of a reasonable amount to a certain extent. What is reasonable would depend upon the size of the Karta's, the HUF's property, its bank balance, income, etc. But yes, it can. But it should not be exorbitant and out of the blue.
in the video will, no documentation except the recording of the video. Video will.
No, there would be a will. A will is a must. But it's just that the whole process of signing the whole will is read out. In addition to the document is a must. You're not doing away with the document.
Thank you.
I think, thank you. We'll take questions offline. Before we go for a break, we have a few announcements to make. First and foremost, this will be our last session before Diwali, so I wish Happy Diwali and a Happy Hindu New Year from Borivali Central CPE Circle to all our members. Secondly, our next seminars are scheduled. We will be posting them on website. The most important seminars we are likely to hold is on the standards of auditing and code of ethics. We are trying to have them in the month of November, but there is a blackout period announced by WRC from 6th November to 26th, so those will be on weekdays, mostly on 29th or 30th November. We are trying to schedule the same, so if anyone has missed out those particular seminars and have received emails, so we are scheduling those seminars, and in December month we are allowed to hold only 3 seminars. So if at all your CPEs are pending, kindly ensure that you attend the same. Second announcement will be about the food. Please ensure that you don't have food in this area. If at all you are having, it has to be standing. No sitting food is allowed. We are scheduled to have an RRC in case you have not completed your CPE hours. The RRC is going to be held between 22nd to 24th of December, which will have a 12-hour CPE. We have 2 rooms still left, so in case still if anyone wants to register, we are here to register them. I think with this we break for 15 to 20 minutes.
Before that, 1 sec. Members, 1 sec. Dr. Sir would like to say something to you.
Hi, good morning everyone. This has been the most interesting session, and for me to come all the way, actually I was in Cuff Parade only, but it was of great use. I have only one question before we go to break. One question. We have been sitting here now for 2.5 hours listening to him. You can raise your hands or not. How many of you are having now pain in the back and pain in the neck? So, those of you who have, please come back after the thing. Those of you who don't have, also come back.
Everyone please settle down. Those who have already finished it, I would request everyone settle down and please come in front. Request to please come in front. It is comfortable to everyone. Because Dr. Sir would like to be very lively with everyone. So if you are in front, it will be much better for you also.
If you have to solve your back problems, you can't sit in the back. You have to come to the front. Thank you.
I would request everyone in the dining section, please come and settle down, please. We have to start the session. All the members, those who have completed, please settle down.
I think welcome back to all members. Before we officially start our second session, I think Anup Shah sir, the seminar was so mesmerizing that in that moment or before going to the break, we actually forgot to give him a formal vote of thanks. Not forgot, but we initially thought that he's going to stay back. But then it was just in that zone. So before to give a formal vote of thanks to our first speaker, CA Anup Shah.
Thank you, Pradeep Bhai. It is a great privilege and honor to propose vote of thanks to CA Anup Shah sir. He has covered topics like estate planning, family trust, Hindu Succession Act, HUF, partition, etc. in a very detailed and crisp manner, and he has covered in a most practical way using the PowerPoint presentation. He has covered various scenarios, case laws, examples for the benefit of the members. He has answered questions and queries asked by the members. As it is said, creating a registered will is like securing your legacy in the vault of legality, ensuring your wishes endure beyond a lifetime. Thank you, sir, for sharing your knowledge. Now I request members for a loud applause.
Before we hand over the mic to Dr. Samir Dalvie, I would just like to thank his team, Dr. Muthu and Dr. Dileepan also here. So kindly a big round of applause for both the doctors who have also come over here with his team. Thank you for giving your valuable time on this day. Now I would request sir to please take charge of the session.
So, good afternoon everyone or good morning. Thank you for staying. आधे लोग चले गए, उसका मतलब ये है कि उनको हेल्थ से ज़्यादा या तो एस्टेट प्लानिंग का वैल्यू ज़्यादा लगता है या तो ब्रेकफास्ट का वैल्यू ज़्यादा लगता है, क्योंकि लोग लेक्चर और ब्रेकफास्ट दोनों लेके चले गए. अभी प्रॉब्लम क्या है, आप लोग थोड़े बेटर हो, क्योंकि जो प्रॉब्लम अभी क्या है, जो आप मुझसे सुनने वाले हो, अगर उनको सुनना है, उनको एक एक को 2,500 रुपया देना पड़ेगा. आपको फ्री में मिल रहा है, क्योंकि वो आएंगे तो मेरे ही पास, बराबर. हाँ जी, नहीं थोड़ा एक्चुअली हो गया जा स्टार्ट आ गया ना आ जाएगा so topic is back pain and neck pain, both of that. And when Nilesh bhai approached me, initially I was hesitant because I give lectures not even to doctors, I give only to specialists, orthopedic surgeons and neurosurgeons. So I thought कि मैं common public में मैं lecture दूँ तो what? But then I realized, because what happened is that his father unfortunately got a spine problem. He got it in the month of September. And I was seeing two things. My CA chasing me, ki, "Arey baba, document do. And him saying, "I don't have time, only after 15th, I have to do GST, I have to do last." Then I realized that there is no better opportunity, because you CAs are going to be our best patients. Because firstly, you have to sit all the time, you have to look at computers and documents all the time, and you have this constant stress, 15th ka date, 30th September ka date, this, that. So who better than CAs? Plus, of course, we will joke about each other's charges, but you all charge also quite a bit, so you can afford us as well. So I'm sure you are going to be our best clients. So the important thing is, what I said is this first thing, that 8 out of 10 people have had or have backache. 10 में से 8 जन को backache होता है, और हमारे around 40% चले गए, बराबर? तो उन सबको backache तो कभी ना कभी होना है, आना तो है. But the thing for this is that what I say, that 8 out of 10 have had backache, okay? And can anybody raise their hand who has never had backache? 2, 3, 4. So these 4, 5 people, they have got another disease, that is poor memory. So everybody has backache. So it is not possible that you have not had backache at least one day, at least once when getting up from the chair, at least once from lifting on the weight. And this spine is one organ which God has made in such a way to make, I think, spine surgeons rich, because everybody has backache. And there is a very deep reason for it. Because initially, as you know, people were quadrupeds, like your dogs and cats, on 4. So when you stood straight, we got the big advantage of, being able to rule the world. But the disadvantage was on the spine, because the spine was not meant for that. And that is why people have spinal problems. There is no other reason. So everybody has backache. It's like a universal problem. And it is also the commonest occupational disorder. So there are some things which are known as occupational disorders. And so there are many occupational disorders. There is tennis elbow. There can be many occupational disorders. But if you group occupational disorders or occupational disease, back pain is the most common occupational disorder. And it is also the second common cause of days of work. So when you, like in US, where they maintain these records, or companies where you maintain records, then you see that among the causes of days of work, chutti, back pain, is the second common. Any guess which is the first? So it is common cold, but in India it would be India-Pakistan match. So India-Pakistan match hoga, so everybody's on leave. So anyway, yes, common cold is the first one, and the second one is back pain. It is also the leading cause of disability in this age group, in the middle age group. And what is interesting, it is as commonest across all occupations. So this is one thing where whether you're a sedentary worker, your office, IT professional, or that, whether you're a doctor, or whether you are a hard laborer, like it is even in the sort of labor force, or construction workers, sewer workers, all of that, sportsmen, cricketers, etc. If you see, most of the times when a player goes off, it's because of back issues. So it is not only the commonest occupational disorder, it is also the commonest across occupations, which is very important. So when you see this, it's the commonest in office workers. And this is why this photograph actually shows you why that situation is there, because this is how you are the whole day, and because your mind is now diverted, your mind is not thinking of your back and neck at that point. At that time you are thinking of whether a balance sheet balance हो रहा है कि नहीं, ये मैं इधर डालूं कि ये मैं उधर डालूं, कितना tax भरना पड़ेगा, all of those things. So you are not really concentrating on how you are using your body, and that is why at the end of the day when you're finished and you go home, that is when you pay the price for it. So I mean, if you just look at this guy, he's not an office worker. I mean, do you think this guy has backache? Absolutely, because he's got all of that. He's got poor posture, he's got lack of exercise, he keeps getting repetitive injuries because of this, and the biggest thing is maybe this guy doesn't, unless again I'm saying he's watching a match, but other than that, stress. So stress is very important. Like that's what I said, when you realize that. So even in homemakers, this is a huge part of, as an occupational disorder among homemakers, previously called housewives, but they also have backache as one of the biggest problems. I mean, those of you who have non-working spouses who are only at home, you will realize that they will keep complaining about backache, because they also have to do all the work, everything else, and plus they have stress. Plus those of you who are CAs, you must be reaching home at 11 o'clock and not paying any attention to them. So the only way they can get your attention is by telling you I have backache. Mera Dr. Dalvie ka appointment le lo, so you spend 2 hours traveling to Mahim, 2 hours coming back, and 2 hours sitting outside. So 6 घंटा उनको मिलता है. Even if they take you for a movie, they will get only 2 hours. So anyway, so coming to back pain, grossly it can be classified as mechanical pain, inflammatory pain, which is because of some kind of inflammation, sujan, disease, and neurogenic pain, which is because of nerves. So mechanical pain is a purely physical problem with the structure and function of the spine. So the spine is like, if I was giving this talk to architects, I would tell them in different ways, but you have girders, you have joints, you have concrete, you have all of that. If I was giving it to automobile engineers, I would have given a different talk, because you have shock absorbers, you have pistons, you have all of that. For you, I don't know what to say, but the point is that it's a mechanical structure. Eventually, the spine has been designed in such a way, it's a mechanical structure which allows you to bear weight, but allows you to bend, allows you to move, and it also sort of protects the nerves which are going inside. So this is one patient had come, we did his surgery, and he refused to pay my fees, so maine uska spine nikal liya. Anyway, jokes aside, this is the model, but this is what it is. So there is movement as well. So it has everything. It has strength, plus it has movement, and it protects the nerves. So that is why it is such a vital thing. But because this is so delicately and beautifully balanced by nature, it is also prone to dysfunction. If that whole system is upset slightly, then there can be dysfunction, and a dysfunction is what gives you pain. But the hallmark of this is that it is aggravated by activity and relieved by rest. This means that if you visit me ever in the clinic and I'll ask you, are you okay when you lie down? And do you get it only while sitting, standing, walking? That is a mechanical pain. So mechanical pain is caused because of all of these. So the whole structure of the spine is not only what is in this model, but even your muscles play a role in it. Muscles, there is some hydrostatic pressure, there are ligaments, there are discs, there are a lot of other things which take part in that. The second is the inflammatory back pain, and this is a little important because mechanical back pain is very common. When I say that all of you or 8 out of 10 have back pain, it is a mechanical back pain, which everybody gets sometime or the other. Because like any organ, it is, any mechanical structure, it is going to at some stage not work. This is the important one. That is when there is a disease in the spine, and there can be many diseases in the spine, which I don't want to give in great detail or scare you with, but you can have infections in the spine, like a TB, you can have tumors in the spine, you can have cancer going to the spine, you can have osteoporosis, all of that. So all of these diseases can also cause backache. So therefore, it may be 1% only, but you cannot ignore it, because 1% is still a big number. And this is because of problems in the nerves, so that's a different issue altogether. Here you get numbness, weakness, janjani thai, chalne mein problem, all those kind of stuff. So how do you get mechanical back pain? Why? I said it's a structure, so a structure can fail, and if there are repetitive minor injuries, which you get every day, like even just sitting for too long in one place or any movement or anything, you can get minor injuries, and this gives rise to degeneration or wear and tear. So it's like when you're driving a car on the road, no matter how carefully you drive, the tires get worn. Now within that, there may be some situations where you drive carefully and the roads are very good, like in Europe, and the wear and tear is less. In India, you've seen how the roads are and how we drive. So the wear and tear may be more, and the wear and tear in medical terminology is known as degeneration. On that degeneration, so there is a general degenerative process which is happening from the day that you are born. So it is not necessarily, even if you're 25, your spine is still 25 years old because you got the spine when you were born. If you're 50, it is 50 years old. So there is a wear and tear which causes an inherent or an intrinsic weakness. On that, if you get an acute injury or strain, like यार आप एक जगह पे सपोज आपका वो दिन कुछ आप एक दिन आप 10 घंटे बैठे 11 घंटे बैठे, या तो आपका अच्छा आपका जो नॉर्मल अच्छे क्वालिटी का चेयर है वो नहीं था उस दिन, या टूट गया, या किसी और ने दूसरा चेयर लिया, या तो किसी क्लाइंट के ऑफिस में गए उसका चेयर अच्छा नहीं था. सो दीज आर द स्मॉल थिंग्स. या तो द अदर थिंग इज यू लिफ्ट अ वेट विच इज अननोइंग. सो what does that mean? You can even lift a 30, 40, 50 kilo weight with your mind knowing it's 50 kilos and nothing will happen to you. But even a 5 kilo weight can cause your back to go if you are unknowingly lifting it, or if your back is not ready for it. So one of the commonest patients I get, and nowadays it's throughout the year, but previously it used to be in summer and holiday season, is that they say, I'm flight leke aaye US se, or when I was taking my bag off the trolley, I got backache. Because this person has sat in that AC flight for 12 hours, his back is stiff, and then he's lifting a weight which he has not realized that his bag is 30 kilos. So that is when they get. So this is an acute injury or a strain, and this gives rise to the acute back pain, the severe back pain. So this is not chronic back pain. This is not the back pain which is always going on. But acute, kamar bhar gayi, lachak gayi. Some people may tell you slip disc, though it is not. But this sort of pain. And when that happens, it always gets better. So while the bad news is that almost everybody gets back pain, the good news is that it always gets better. माने वो अपने आप ही अच्छा होता है, right? So for this acute back pain, when you come to a doctor or a spine surgeon or somebody like me, or you go to a hard vaidya, or you go to acupressurist or acupuncturist, right? All we have to do is entertain you while it gets better by itself, and then we just collect the rent, tax on that, right? पता है 2 हफ्ते में ठीक होने वाला है, तो 1-2 बार जाके आओ हमको जरा, हाँ? So anyway, so point is that these acute back pains get better. There is nobody who has an acute back pain which has remained forever. It gets better. It may take a day, it may take 2 days, it may take 10 days, may take 15 days, but it will get better. But when you do that over a period of time, again you get acute, because that process still continues, and you are going into that process again and again and again, and at one stage you then land up with this chronic backache, means constant backache. So that is the worrisome problem. One of the other issues is the way, our muscle tone, etc. is not good, and you have just poor posture, even while standing. So if you have this kind of a posture, which most of the people, and especially the young people have, is you're not standing straight, your shoulders are hunched, your back is pushed out, you're not standing properly. So even this posture is a problem. But for you people, this is the problem. So, your use of the computer, chair, your workstation, and this is actually the most important thing, for the simple reason that you people especially, or IT professionals or office workers, you are in this for 5, 6, 7, 8, 9, 10 hours. It is not that you are sitting for 5 minutes. And at the same time, your mind, like I told you, is diverted with actually trying to do your whatever assignment is there, and you are not paying attention to your posture. The other thing is that, people may spend 50 lakh ka Mercedes ले लेंगे, but वो 10,000 का अच्छा chair नहीं लेंगे. So with that, this is the problem, where you are spending 15-20 minutes in the car, but you are spending 10 hours on your chair. And the other issue, which may come to later on, is this craze, so I'm not going to linear order, of laptop. So how many of you use laptop all the time as opposed to desktop? I think most people. So I think what has happened is actually a laptop has been invented when it was invented, because I am from, and many of you are from that era when desktops came. Laptop was invented for mobility. It is not invented to be used. In those days, desktop used to be 20,000, laptop used to be 1 lakh. So people bought a laptop only if they need mobility. It was a luxury. Today, desktop costs 60,000, laptop costs 30,000. So everybody buys laptops. But a laptop is not meant to be used constantly. It is only meant to be used by people who need to move from place to place, right? And the problem with the laptop is that the screen the keyboard and the mouse, they're all together. So you're just crouching and working, plus it is kept on the table, right? And that is one of the biggest problems. And what has become worse is with COVID, is this work from home. Because COVID के पहले भी work from home कर सकते थे, लेकिन किसी ने बोला तो उसको 2 चाटा मिलेगा कि घर पे कौन काम कर सकते हैं. But अभी कैसे ऑफिस वर्कर्स घर से ही काम करते हैं. और जो अभी निलेश भाई ने मुझे बोला कि उनका ऑफिस और घर बाजू बाजू में है, तो कभी वो जाते होंगे ऑफिस में, पर कभी भी घर पे भी बैठ के करते होंगे. You may be sitting at home, and even though your office infrastructure may be good, at home people will sit on the dining table with the dining chair or this, or even worse, when I speak to the younger generation, they do stupid things. They just sit cross-legged, palati maar ke, they keep a pillow on their lap. Others, they lie down, keep it on their stomach and type. So all of this is going to cause problems. You are going to pay the price for it. So that is the issue with laptops. And I'll tell you what to do about the laptops in some time. So what are the risk factors for back pain? One is increasing age. Obviously, I have said it is wear and tear. So as the age increases, obviously there's going to be more wear and tear. Smoking is very bad. I mean, if I can, smoking is bad for anything and everything. It is not just bad for your lungs. It's not just bad for your heart. It is, from my point of view, bad for your spine as well, because it creates a lot of issues. And people with chronic back pain, nerve problems, etc., most of them are smokers, because it's really a very toxic habit. Poor strength of your back, that we will come to later. Psychosocial factors, stress and anxiety, which is one of the biggest factors for back pain. Like most of the patients who come to me with chronic back pain, the root is actually stress or anxiety. And when you look after that, most of the problems tend to get solved. Occupational factors we already spoken about, whether it is sedentary, whether you're sitting in one place. And our last speaker told me, he took away my first sentence, which is that sitting is the new smoking. Because sitting is really terrible, but there is no choice, and he has solved that problem, or it has been solved, but he is using that by using a standing desk. So you have a standing desk, so you're not constantly sitting. You can't constantly stand either, but you get a desk which goes up and goes down, so you can sit for some time, stand for some time. So these occupational factors can be there, or it can be whether you're a heavy worker, construction laborer, you're constantly working, you're constantly lifting weight, all of that. Doctors, we are constantly, if you're operating, we are bending and working. If you're in the clinic, we are sitting the whole day. Nurses, they are doing nursing care. So you pick any occupation. Sportsmen, we have already told you, because they use their body and they try to push their body ahead from what it can achieve at the time of sports. So all of that is also there. Job dissatisfaction also is something which again gives rise to the psychological thing. And weight. So I think I see a lot of people who come in very much overweight, and they come in, and then I don't even know why, because they have come there to pay me 2,500 rupees for me to tell them to lose weight, which they already know. It's not that they don't know, but they want me to tell them कि भाई वजन कम करो. हाँ बराबर डॉक्टर, बहुत अच्छा एडवाइस दिया. And 1 year later they'll come back and they'll say मैं वजन कम किया? नहीं. Okay, no problem. Another 2,500. वजन कम करो. So that is the thing. Repetitive lifting. So that is for construction workers or factory workers. And a sedentary lifestyle. So you can see there are two opposing things. One is too active and the other thing is inactive. But both of them are bad. Obviously the answer is somewhere in the middle. It's moderation. It is not trying to do only one thing. Slide atak gaya. That's another risk factor. Anyone is there? IT wala koi hai? So a little, because I realize one thing, that people somehow or the other, they don't pay much attention to biology in their school, those especially who go into these financial sectors. So they are a little lost as to what is anatomy, and then patients come and they are completely lost. So this is a spine, the lumbar spine, what you can see in front of you. And what happens is that there are two vertebrae, and the vertebrae are made of bones. This is bone, haddi. And between them is the disc, which common terms is known as gadi, or slip disc bolte hai. And through that the nerves are traveling. So this is your lumbar spine, and that is known as a spinal segment. Now this disc, if you see from the top or whatever, it is like why the body has made it. It's a shock absorber. You can move. It's like a joint. So it is a joint to move, but it's also a shock absorber, because you can imagine if there is a rigid bar like this, there is, there is no resilience every time you get any movement, any jerk. So this has this axial movement also. So it is a shock absorber come a joint. It's a very interesting thing, and nature has made it so beautiful that the way to make this is to put in a jelly, a hydrostatic jelly, which is contained inside a rigid thing. So there's a soft jelly which is contained into a hoop, which acts as a shock absorber and a joint. So it is a very beautiful organ. But the problem, so this is the outer thing and the inner jelly, and the spinal cord or the nerves are behind it. So that is the anatomy. So I'll come to the problem, what happens to it, what is slip disc and all I'll come to later on. So like I told you, for a simple acute back pain, actually it gets better by itself. So you don't need to do anything. But like I said, we have to try and cut down the suffering. We need to make the patient feel more comfortable. So obviously rest is the most important thing. Like you are not going to, if you have a car with a punctured tire, you're not going to drive the car, right? So that is the same thing. You have got a damaged back. You are not going to stress it. You are going to rest it to get it better. Medications, there are various medications. There are painkillers, etc. I'll come to that later on, because self-medication is a problem, or improper medication can be a problem. Local applications, you can, apply your move, apply liniment, sensor oil, all of that. Heat or ice, which also is very important. And as a general rule, if you have an acute severe back pain, ice is better. And a long-standing back pain, then heat is better. And then finally, a rehab. So rehab is very important. So I'll come to that. Rest is done only during the acute episode. So the olden concept of you have a slip disc and I was on 3 months of bed rest, that doesn't work anymore. We only give 3 to 5 days of bed rest. Beyond that, it has been shown that rest is not of any benefit only. And once that initial period of rest is over, we actually encourage people to go back to their activity levels, because there has to be some movement, some chalna to the spine. Only then it will work. Braces or belts, people like belts. I don't like belts, because what belts do is they weaken your spine. They take over that spine and they weaken the spine, and that causes more problems. So for that short term, you will feel okay. See, it is like your child is doing exams and you are teaching the child to cheat, right? You're copy karo. But that copying he will get more marks, but for the rest of his life, what he will do? He is becoming weaker. So it's the same thing with belts and braces and collars. Of course, I meant that. And I very rarely would give it, because the problem is once you give a belt, they will use it, they will keep it in their cupboard, and then they will keep taking it out. That is one. And some people constantly wear it. So you see, Pelt Peno, Nicolo, they'll make a big drama and a show about the whole thing, when it is not required actually. And they just get totally mentally dependent on that belt. Collar is the worst thing actually. Collar is by far the worst. It really damages your neck. And you'll feel better for that point of time, but your neck will get so badly damaged that in future, you can never come out of it. So I said, like I said, the problem is it causes muscle weakening. What about medication? Medication actually, like I said, the back pain, there is no treatment ki ye back pain ka dawa. Yes, you go to a doctor, he will say ye back pain ka dawa hai, but there is no such thing. It's a painkiller. You take it, it's a painkiller. But a painkiller is not one drug. If it was that simple, if for instance doing an audit was that simple, we would have only done it. No? Why we have to give it to you? You understands everything and you do it. So same thing, there is no one painkiller, otherwise everybody would have been a doctor. There's a whole group of different medications, each with different indications, different contraindications. कोई किस एज में लगता है, कोई किसी को kidney problem है तो we can't give, blood pressure we cannot give. Each one has a different set of complications and side effects. Each works in a different pathway, and that is why we know that. So you should never take it without a prescription. Don't take it without a prescription from a proper doctor. The other thing is, don't go to 3 doctors and use all 3 prescriptions, because one doctor gives a prescription on a particular base. That doesn't mean that if you take 3 of them you get better. You will get complications rather than getting better. And some of them have very dangerous side effects. Like often people come to me and I tell them you need surgery, and I'll come to that later, but since I'm here, and they say नहीं surgery से बहुत डर लगता है, हमको दवा दो. But surgery से डर लगता है क्योंकि आपको लगता है कि surgery कोई dangerous चीज़ है, पर दवा भी dangerous है, ये आपको पता नहीं है. आप ये वोवरान या डाइक्लोफेनेक आप 2 हफ्ते खाएंगे, आप if you have a kidney shutdown, if it's permanent, you will be on dialysis thrice a week for the rest of your life, and you will have to then find your wife or brother or cousin for a kidney transplant, and you end up spending 30 to 50 lakhs on that. Why? Because you want to avoid one surgery. So everything has side effects. You can take painkillers. 2 painkillers can cause so much of bleeding that patient can almost die. So I'm not saying all have it, but what I'm saying is that don't think that medicines are something which are safe and you can take medicines forever as opposed to the proper treatment. And long-term use is very dangerous. The worst thing, again, is when people go, because suppose I go to the chemist sometimes and I'm taking my medicines, I see people come there, "Arey, oh, kamar dukh raha hai, zara dawa do." So you just go on taking from the chemist without prescription. So in India, things are not controlled. Abroad, if any of you have traveled abroad, you realize you can't even get a painkiller unless you have a doctor's prescription. But India mein sab kuch chalta hai. But then the problem is that pharmacist or that guy, he wants to sell his medicine. He's not aware of what is your medical condition, what you can take. And if you land up with a complication, you can't go and tell him. And you may not even know that it's caused because of this medicine. While we are on the topic, people think, another favorite grouse of mine, people think ki Ayurvedic acha hai, no complications. And now because these people have taken radio time, Baba Ramdev and all these guys, you all think ki Ayurvedic sabse acha hai. But it is the biggest lie. Ayurvedic medications are those which are absolutely not tested in a laboratory. There is a reason for this science. Like you have a science of how to prepare a balance sheet, what is tally. There is a science behind it, right? I can't just say that I'm going to write accounts. I cannot say I'm going to file my IT return. There is some science behind it. So every single medication which is given to you by any pharma company has a huge rigorous testing protocol going through 5 stages: lab testing, animal testing, human testing, 10 years result, complications, data maintained, and only then that medicine is made into a medicine which is sold in the US to you for $20 and here for 20 paisa, because abroad they follow the laws, and there is a reason for that. Ayurvedic is in some ways safe because it's done from jari booty, this, that, in some ways, but some of them contain very dangerous things such as heavy metals, arsenic, lot of toxins, and you don't see those problems because those problems don't come to you, but patients, they are seen in the hospital. They will go with some kind of poisoning, they will go with kidney failure, and nobody knows why. It is because of long-term taking these Ayurvedic medicines, and so they're untested. It is not true to say that these things are safe in the larger picture, right? Because allopathic medicine goes through a very rigorous testing protocol before it is given to patients. Coming to local treatment, again, ointments and lotions are fine, and many of them are safe. So most of them are safe, like Move, etc. Any of these, Sensor Oil, Myostal, Liniment, they are safe because they don't contain any drug. They contain local applications which at the most may cause a skin reaction at the most, but it is safe. You can use it once a day, twice a day, 10 times a day, no problem. Some of them, however, contain a drug, which is a new thing which has started, a drug. For instance, the most common one, because it's advertised, which is wrong, is Volini. So you'll go on applying Volini. But suppose you have a contraindication to take diclofenac, that is Voveran, Diclonac, all of that. This contains the same drug. So if you go on applying it, it can get absorbed and cause the same complications. So you have to be careful. Like I said, Madiwala liniment, all the liniments and all are fine, but some of these creams are dangerous. So don't, again, self-medicate. The only thing is skin reaction can be a problem, and heat and ice we've already spoken about. Heat and ice is safe, means unless you burn yourself. So I have seen patients also who come with completely red skin because they just keep on putting heat. And the electric hot pad is very useful, but you may miss, especially there are people who put it on and go to sleep, and then they may just wake up with burns, which is quite a big problem. So after this back pain gets better, comes the next phase, because like I told you, back pain always gets better. And that is rehabilitation. So rehabilitation is the most important thing in back pain. And in that there are various sort of phases. There is exercise, there is lifestyle modification, and also understanding the problem. Like if you understand the problem, then you can come to the solution of the problem. And we call it back school. You have to understand how your spine works. You have to understand what stabilizes. So it is not just, because like I told you, the ligaments, etc., what stabilize the bone, the disc, we cannot do anything about it. But one very important thing which stabilizes your spine is the muscles. And these are the muscles of your back and abdomen. And that is something which we can train. That is something which you can do actively to help yourself. And your posture, that is maintaining the correct posture. Like see, this is a wrong posture, leaning forward, slouching. These are wrong postures. Those are the things which are in your hand. You can control and give a correct posture. And the other thing is your muscles. So your muscles, you can have a good balance between flexibility and strength. So these are the things which you can control, right? and which you have to work on. So sometimes patients come to me that I can walk only 1 kilometer, I get backache and all, and mera kya hoga? But I said with exercises you can climb Everest also. It just depends on the level of exercise. If you do one level of exercise, from 1 kilometer your thing can go to 2 kilometers. If you do that level of exercise, you can climb Everest also. So we give different kinds of exercises, spinal exercises, abdominal, because the abdominal muscles also look after your back, and pelvic floor exercises, and general toning exercises, your rest of your arms, legs, etc. So exercise is the one thing which is in your control. It is the easiest. Once you have learned it, it's the cheapest because you can just do it at home. And it's the best way to maintain your health for the spine and for other things also, which I'm not talking about, but for the spine. So we do strengthening exercises, different sorts of isometric, isotonic, and even aggressive exercises at a later stage. And they teach you how to relax your muscles and how to make your muscles work better. So when you do strengthening, right, you get a natural corset. Corset is belt. So when I tell patients, instead of wearing a belt, you do exercises. Because the same thing like a belt, your entire muscles around your back and abdomen, if they are strong, they will act like a belt. And it's like a natural corset. It's a natural corset, right? And that is known as a core exercise. You might have, if you have any time gone to a spine surgeon or a physiotherapist, they will tell you core, C-O-R-E, core. So that is this core has to be strengthened for you to this. After that, there is general exercise. The general exercise also is important. Of walking is the easiest and the cheapest. Swimming is very, very good, but it is not easy. You have to have a membership or something. Plus, it takes some time. You have to go, change, shower, so that. But otherwise, swimming is a very, very good exercise for people who have a lot of joint pains and are not able to walk. Walking in water is very good because it's very smooth and it doesn't cause problems. And then cycling also is a very good exercise because it's a very general kind of exercise which helps you, whether it's on the spot cycling. Cycling outside also is a very good exercise, but if somebody knocks you down, then you are in hospital. So that's the only problem. So the commonest thing, so there are loads and loads of disorders in the spine which I cannot go through here, but slip disc is one thing which you commonly hear. So what actually happens? What I told you all is that the disc is a jelly which is inside, which is contained by an outer thing like a hoop. So if that outer hoop tears and that jelly comes out, that is known as slip disc. So when that jelly comes out, it is like a soft toothpaste, but once it comes out, it becomes hard. And with that, if it comes out, I've shown you these nerves, it can press on those nerves. And if it presses on those nerves, you then get pain which goes into your legs, and that is known as sciatica. So many people ask me, मुझे sciatica हुआ है कि slip disc हुआ है? But they are both the same thing. Sciatica means pain going down the leg. Slip disc is an issue in the back. If you have only back pain, it is not slip disc. If you have pain going down the legs, that is known as slip disc. And you can also get some numbness or weakness, etc. And whatever spine disorders we treat seriously, that is we treat with surgery, for instance, are not backache. So almost impossible that somebody advises you surgery for back pain. The surgery is done for the nerve issues, which is pain going down the legs, numbness, heaviness, not able to stand, not able to walk. And that is the reason why one would do surgery. So for this acute disc prolapse, this treatment is very easy. It is conservative. So 9 out of 10 patients get better with just rest, and more than 90% improve. Most improve in the first week. You return to activity and again do rehabilitation. And surgery is done only for a few cases. So if there is an emergency like a severe numbness or weakness, or they lose control of the urine, they are really not able to stand. And and elective is another one. Elective surgery means it is not getting better. So you are waiting, but you continue. You are not able to stand, not able to walk, not able to go to office. It may not be so bad that you are in the bed, but you are not getting better. Then one can think of doing elective surgery. See, another thing is osteoporosis in the elderly age group, which means weakening of bones caused not just by low calcium, but by a lot of other issues which can cause. So you have these sort of x-rays, that the calcium is low, there may be fractures, etc. And this requires treatment. So women after the age of 40 will lose calcium. Men after the age of 60 will lose calcium, and their bone density becomes worse and worse. So the only way to do this is to build it up to a very high level before that, and after that you maintain it constantly. And we maintain it with medication, that is calcium, vitamin D,
and some of the other medications which are there. Weight bearing exercise. So exercise is important. So when you do a weight bearing exercise, that strengthens the bone as well. And some proteins, etc. You need a high protein diet, a good protein. So the problem with Indian diet is that it is low protein, high carb. So we eat chapati bhaji or dal bhat. All of that is low protein, especially the vegetarian diet. So that is not a very good diet. Calcium, etc. Many people after the age of 40 cannot tolerate milk. They are unable to have milk and milk products. So the calcium goes down, proteins go down, activity levels goes down, and many people get osteoporosis after 40, 50, 60. Women, you see, they start bending, they start getting aches and pains. So this is also a very important thing, bone health, which you need to look after. So therefore, what do we do? Like how, from this dismal situation where it seems everybody has back problems, what do we do? You need a more active lifestyle. That is really important. If you are just going to live here, go by rickshaw, do work every day, go home and sleep, you are not going to get better. You need muscle toning exercises. Weight control is very important because like I told you, it's a mechanical issue. So mechanical issue means if every day the loading on the same thing is more, if your weight is 80 kilos, right? It's like a 60 kilo person lifting a 20 kilo weight every day. If you're 80 kilos, simple. So weight control becomes very important. Postural care, especially occupational. So that I'll come to for you people, what you need to do. And avoid silly exertion. Silly exertion are weekend cricketers. Weekend cricketers means what? No exercise, nothing. And one Sunday cricket match, 20 over cricket match khelne jayenge. They'll go and bowl and they'll land up in the back. Right? So these weekend cricketers or weekend sportsmen are doing a silly exertion. Nobody is saying don't play cricket, but train. If you're training 3 days a week and then you play a match on Saturday and Sunday, it's fine. But if you are just doing office work for 4 months in a row and one day you go to play, you are going to damage your back. So a few myths of back disorders. Myths means, as he also said, myth of will. First is that only some people have back problem. So that we've already figured out that everybody has a back problem. Second is once a back problem, always a back problem. Ek baar ho gaya means to lifelong ho gaya. It is not necessarily true. I've explained to you. Exercise karenge, weight control karenge, medication lenge, you will be fine. Most of the patients who get acute back pain get better. No, they don't not get better. There is nobody who has had acute back pain for the rest of their life. Long-term rest is needed. ये भी गलत है. जो लोग बोलते हैं ना 3 महीना 6 महीना bed rest, कभी भी नहीं. Not more than 5 days rest and that. The next myth is that your neighbor, granny, driver, friend knows best. Because this is the biggest problem कि that we give some advice. फिर अरे वो बाजू वाले ने बोला था कि ये करो तो फिर अच्छा हो जाएगा. That sort of thing. So they don't know. Everybody is an expert, especially in medicine. So everybody is an expert in India. On back, so everybody is an expert. Everybody, you tell somebody कि ऐसा I went to Dr. Dalvie, उन्होंने surgery बोला. 20 people will give you different advice. नहीं अरे ऐसा करो वैसा करो ये इसके पास जाओ उसके पास जाओ. But they don't. They cannot possibly have the same level of understanding that somebody who's had 15 years of training and 20 years of professional experience, what they have, you cannot just possibly have. Medicines are safe. I've already talked to you. There are complications, side effects, etc. And this is a big myth that surgery means the end of the world and should be avoided at all costs. So nobody wants to have or do unnecessary surgery. But surgery, especially modern surgery, what we do is not the end of the world. We do surgery and most of our patients return to what they were before. Whether they are sportsmen, whether they are working, whether they are whatever, they completely return to their life with modern kind of surgery. Surgery is risky. This is also a thing. There is nothing which is not risky. You from Borivali, if you want to come to Hinduja, you take a rickshaw, somebody may knock you. You go to the train, somebody may push you out. You get on the bridge, you'll trip and break your leg, and a fan may fall on your head. Anything can happen. So that way it is. But surgery, modern surgery, the way it is done with all the equipment, infrastructure, expertise behind it, is not risky. Maybe complications, 1%, but it's not risky. Surgery is invasive. So there was a time when we used to do very big operations, big cuts and all, but now we are doing smaller and smaller. So we do incisions through chota scars in many of the cases, not in all cases, but many of the surgeries are small surgeries with very small holes. We don't even use stitches. Patients get discharged in 1 or 2 days. And we use this kind of special instruments just through a small hole to do the operation. We use microscopes through a small hole we can see what is happening. And we don't need to make big cuts anymore. And with microscope, etc., everything is seen very beautifully. There's no question of damaging. People say nas cut jayegi and all. It cannot be. It's the job what we do. It is every day we operate. We're doing 500-600 surgeries a year. So obviously we are not going to damage all of that. And also patients are not bedridden after surgery. Patients are made to mobilize very early. Most of the younger patients get up, walk within hours of surgery. And it is not that surgery ke baad bed rest lag jata. It doesn't work that way. So coming to prevention, basically you have to, some things which you have to do. So sitting properly is very important. So the first one is wrong sitting, unsupported. The second one is slouch sitting. That is unsupported. That is not proper. And low sitting. So you should avoid low seating, avoid slouching. You need to sit back in the chair and be well supported. Lifting weights as well. One is not too heavy, not in the wrong way. Like if you keep it too far from your body, the lever arm is not working. So if you want to lift something, you must make the lever arm short so you can properly. So if you bend completely from your back, again it's bad. You can just go down on your knees and bend. So this for instance is a better way of lifting it and keeping the weight closer to you, if at all you need to lift. So basically keep the weight close to the body. Bend your knees when you're bending down. When you're sitting, you sit on a firm seat with a straight and supported back. When you sleep as well, you need to use a firm mattress. So don't use a memory foam mattress if people are buying mattresses, because the memory foam is too soft. You need a firm mattress. Previously there used to be coir and cotton, but it is now out of favor. But you can use a bonded foam mattress which takes the shape of your body but gives you support. The other situation is this, setting up your workspace. So I think this would be the most important slide for you people. So if we go one by one, I think let us look at the monitor. The monitor has to be at eye level. You should not look up or look down. Okay, there has to be a proper distance so that you are not peering at the monitor. The height should be such that it reaches your elbow level, so that your shoulder and elbow is at 90 degrees, and the distance should be such that your arm is properly rested. Your arm is not floating. So this is very important. The distance is important, and that's why you need to have a chair with wheels. The chair should be having this sort of a shape to support your back, and you're sitting back in the chair. So you don't sit on a chair, you sit in a chair. This is very important. You may have a neck support, but you can't always use it because you can't keep your neck back, but you should have the ability to do so. And all of this, you should have the ability to move. So your workspace, because especially you work in one same office for 8, 9, 10 hours, so it is worth to invest money and to make your workspace proper for yourself, and if you have employees, for them also. Because suppose you have employees, you have junior accountants, etc. If they get back pain and neck pain, they will only take holiday, and they will, you will have to pay for their holiday. So that is having this. In addition to this, like I said, avoid the low seating. You should also take breaks. So your neck breaks, every 15-20 minutes you can do some stretches, and every 40-45 minutes you can get up, walk around, stretch a bit and come back. There are back exercises. So I don't want to go into detail. Initially I thought, but then there is no point because you are not going to retain it also. But there are certain back exercises and stretches which you all can incorporate and do even on a day-to-day basis. And that will sort of really help you. But like I said, it's like time has also gone quite a bit. But very simple exercises can be done even when you're, actually we can show, I don't mind actually. So I'll just, 2 minutes, I'll just, simple exercises. So one is a simple stretch like this, okay. Then you go forward at this speed, backward at this speed, left and right, okay. Then you do shoulder girdle, which means you hold here and you can do like this, forward and backwards 5 times. And then you can do a stretch, put it back and stretch like this and stretch like this. So even if you do this much of exercises every 15-20 minutes, you will automatically see the difference, right? Just this much, nothing major than that. And plus you can do a little low back exercises. So the low back exercises in this are a little intense. This is known as the cat camel, where you lie on your fours and you stretch your back up and down. This is a little intense. But other than that, you can just do simple. You lie down, you lift one leg up, hold it for 3 seconds, keep it down. Other leg up, 3 seconds, keep it down. Hold it up, take it out, in and down. That's the second exercise. Then you bend your knee like this and pull it towards yourself. Stretch. 1 left, right, and then both. And the last one is known as bridge. Bridge is you lie like this and you lift your kamar just off the ground. So these few stretches and exercises you can do. These you don't do in office. This you do at home in the morning and evening. But these next stretches you can do on the computer every 15, 20 minutes, every half hour, 1 hour. Whenever you remember, you do these. You just do these stretches and then you will feel much better. So in conclusion, nearly everybody has had back pain at some times. It can be treated with medications and rehabilitation. Surgery has a small but definite role. So although my designation is spine surgeon, we don't operate everyone. I think Nilesh Bhai had come to my clinic and you must be see how many patients are there, but we don't operate that many. Like I must be seeing around 150 to 180 patients a week in my OPD, but we operate around 10. So we are not operating everybody who comes to us. Neurological complications is the problem. So when you avoid surgery, but if you get neurological complications, like weakness in the legs, not able to walk, not able to stand, numbness, that is when surgery is imminent and you have to get it done before it becomes irreversible, because patient, in the fear of avoiding surgery, patient may get paralyzed. Then they will never recover. And you look for hidden pathology. Like I told you, I didn't cover this here, but 1% of back pain is because of serious problems. It can be because of metastasis, cancer, it can be because of infections, etc. So don't ignore it, because you may reach a stage where it is beyond repair. So don't ignore the back pain. Get it seen and sort of get it treated. So I think it's now 1 o'clock, so I will... No, but now, because the only problem is that question answers can go on forever. So we'll just take a few questions, if any, and then... Few questions we'll take. Beyond this, it is 2,500 per question. Also, I must thank all of you for having me here. Nilesh Bhai got me all the way to Borivali, which is like quite a challenge for me as well. And I'm so happy to see so many people in the association coming. And I just spoke and said you have 3 programs a week, which is 3 programs a month, which is huge. This is, I think even doctors don't have so much of continuing education. So it's very good that you all are updating yourself, and of course your own subject is very complicated. It's not easy. Like, I mean, whatever he spoke in the morning is quite complicated. So actually you have to know this and everything else. So
when I met the sir first time, just I told him that, sir, wo jo haath mein thoda dard kar raha hai. So he told that it may be a tennis elbow. So I thought, sir, क्या करना है? तो सर आप कंप्यूटर पे काम करते हो, बंद कर दो. मैंने बोला बंद कर दिया. बोलते क्या बंद कर दिया? सर आपको दिखा रहा बंद कर दिया. क्योंकि सर कंप्यूटर से तो मेरा घर चलता है. So that is not the solution. So he also tell that obviously he cannot tell you that computer पे काम करना बंद कर दो. But you have a solution. अगर if you are working for half an hour, just stand up, make it straight. These are the things we have to take care. So now all yours, sir. Anybody? Questions?
खाली चेकअप करने को मत बोलना प्लीज कोई.
So this used to be typically in school where the teacher says either you understood nothing or you understood everything. So
very nice humor, sir. Some simple question, nothing to show something. It is regarding Ayurvedic medicine you commented. Sir, it is for many years, more than 2,500 years that they exist, number one. Number two, it may not have scientific records and other things, but they are innocent and they do not do any harm, like Harday or Trifla and all. So what do you say, sometimes what happens, that in your body you are not in a position to extract properly, and when you use this innocent, I would not say medicine, herbals, so what is the side effect and what is your opinion about Ayurvedic medicine?
No, I've already told you my opinion. Most of it would be safe and there would be no problem. But there are some which are not safe. And they have things like heavy metal, arsenic, lead, etc. And in the hospital we see patients who come with these sort of vague and unexplained symptoms. When we do their heavy metal, etc. assay and testing, we find out that there is a problem. So, nothing against the system at all. But I'm just saying that the modern medicine or the allopathic medicine goes through a rigorous testing process and a record maintenance process, whereas this is more of word by mouth and passing on from generation to generation and believing, having the belief and the faith. So it's okay.
But it has side effect, no, sir? I mean, normally if you try to remove one disease, another.
So that is actually not true. So there is nothing in the world which can have effect and not have side effect. So if your Ayurvedic medicine is having only effect and no side effect, then that's not having an effect either.
That's
right?
true.
And other thing is Ayurvedic medicine comes from plants, etc. But even the modern medicine comes from that. So the same thing, whatever, like what was there in the Ayurveda, the same plants and trees, these people don't invent the medicines. Except that they isolate the compounds, they test it, they eliminate the harmful and they take only the useful and then they give it in the allopathic medicine. Whereas Ayurvedic is just given as the whole jari booty together.
Thank you.
I'm not saying don't take it, I'm nothing against, I'm just saying be careful. Don't think that that is the answer for everything. So as I explained, I tell the patient whatever works for you, because you put it and see whatever is better works for you is better. But in the larger picture, an acute pain, like suppose just now you bend down and you get a sudden backache, then ice pack is better. But if you have back pain every day, then a warm pack is better.
Sir, carrying backpack is is it okay, or you suggest some other, like you can carry
So
handbag?
between carrying a laptop on one arm and the other, a backpack is better. But obviously if it's too heavy and your back is not strong, then you will have a problem. But a proper backpack which also has the waist strap, etc., it is okay. So for people who have to carry laptops a lot, rather than keep it on one shoulder, it's better to carry it on a backpack. No, so actually brand, though I will not, there is no point because there are different things. The best thing is you have to go to the thing, sit, wherever you feel comfortable and supported, you have to use that one. So it should not be wobbling, it should seat properly, it should be adjustable to height.
सर neck pain और frozen shoulder में neck pain रहेगा और frozen shoulder रहेगा तो what will be the best to exercise on that?
So basically most of them are treated by physiotherapy and exercises. Even the so-called frozen shoulder, they also, like many problems, they get better by themselves, but it takes 3 to 4 months. It doesn't get better immediately. So you have to go for physiotherapy, they will give their physiotherapy treatments, you may have to take some medication and do exercises.
But this neck pain causes the frozen shoulder?
No, they are not. They are separate. Yeah, of course this will help. Like I said, local applications, they work. They will work. Yeah.
Cause of spine and this bones problem. So you just educate us ki, most of the people are 45 and 50 here. How we can keep our calcium level intact or better in time to come?
So I will just explain to you. It is not just calcium, it is also vitamin D. And because the blood calcium level has no meaning, it's the bone calcium which you cannot measure with a blood test. So some people do a blood test and say mera calcium to barabar, but that's not the point. The calcium which you eat has to be absorbed and has to be pushed into the bones. For that you need vitamin D and proteins. Vitamin D in our diet and in Bombay is grossly deficient. If all of you do the tests, most of you will have vitamin D deficiency. So especially if you are vegetarian, and I think in Borivali most people will be vegetarian. So if you are vegetarian, you don't have milk, then your vitamin D will be on the lower side. Calcium also, you require 1000 milligram of elemental calcium a day, which you cannot have. So in short, if I were to just give you one sort of thing is, you get vitamin D tablets, 60,000 units. If you are vegetarian, you take once a month. Don't take more than that. Just take it once a month for lifetime. And your calcium, once you cross 60, you can take any one calcium, 500 milligram, 250 milligram. In addition to your normal food, you just need to take one tablet a day. That's it.
A common problem, I think, normally what I have seen these days, whenever there is a back pain, orthopedic or physiotherapy, which comes first? Normally, orthopedic always says that don't go for physio, and physio always says that before orthopedic, you can do physio also. But normally, orthopedic surgeons just says that don't go for physio initially. The first thing is that, and second, now being a vegetarian, the uric acid problem is facing a lot. So whether it has something to do with back pain or something, or it is a different topic altogether.
To answer your second question first,
uric acid is a metabolic issue. It is not necessarily to do with vegetarian, because actually non-veg food causes more of uric acid, hyperuricemia. But a lot of people have high uric acid, and if it's more than 6.5 or 7, you may have to take the medication for the rest of your life. But everybody doesn't have it. Very few people have. If anytime you're doing a normal health checkup, uric acid comes in that as a test. So if it is high, then you need to correct it. Regarding your second question, see, orthopedic surgeon or medical. Orthopedic surgeon, firstly, let me tell you the difference between the two pathies. Orthopedic surgeon is the one who has come in the first 500 in the state exam, after that done MBBS, then come in the first 10 in the entrance exam, and then he has practiced, and he has had training for 15 years. Physiotherapist has come 20,000 in the state exam, has done a 3-year BSc course somewhere else. So qualification wise, you cannot even start comparing. They use the word doctor because they have been allowed, which is completely wrong. They are not doctors, they are therapists. So you cannot even start comparing a therapist to an orthopedic surgeon. They are not aware, they are not even supposed to prescribe. Actually, if you go to a physiotherapist and they prescribe a drug, they are actually, you can actually put an FIR against them. It is illegal for them to prescribe. They don't have a license like we do to prescribe a medicine, right? So nothing against physiotherapists. What I'm saying is that if you have a medical problem or an orthopedic problem, you should always visit a doctor or an orthopedic surgeon first, who will then prescribe physiotherapy, then you will go to the physiotherapist and do the therapy which is required to treat it, right? It is like, I mean, maybe I'm wrong, but it is like some of you are chartered accountants because you have done particular training and you are member of an association and you have a degree. And then suppose I have one BCom guy who comes to my building who does the accounts, and I tell him ki tu hi audit kar de. Can he do the audit? He cannot do the audit, right? You have to guide him to do the accounts, and then you will do the audit. So it's the same thing. Why orthopedic surgeons sometimes don't, so I refer to physiotherapists. Why orthopedic surgeons sometimes don't refer to physiotherapists is for a completely different reason. The reason is that physiotherapists don't do what they're supposed to do, and they do what they're not supposed to do. So rather than give you the right exercises which will make you get better, they will just keep calling you and they will make 5 patients lie down, put some diathermy diya, ultrasound diya, ye diya, wo diya, and so they will collect their 500 rupees a day. If they do what they are supposed to do, and the way it is, like suppose a patient comes to me and I say that you need this exercise, I refer you to a physiotherapist, physiotherapist does those exercises with you, then that's the best way of getting better. So to answer this question, first you should not go to a physiotherapist, because the physiotherapist is not able to, is not trained to recognize whether you have any serious problem or not. Yes.
One second.
No, so this deficiency can only be seen by a blood test. So if you do an annual health checkup, which I think, especially after a particular age, I think it's a good idea to do. Most of them will have B12 and D3, and then you can take. So D3 you can take oral. B12, if it is low, then injection is the only thing, because orally it is not absorbed so well. Especially in vegetarians, many people have malabsorption. So even 1 or 2 injections, that works. What is the second question? Bone density, so everybody does, it is required after a particular age for women, maybe beyond 50, 55, 60, and men after 70. It's a test which you do. It's a BMD DEXA scan. 1200, 1500 it costs. You do the bone density, it has certain measurements, and if that bone density is low beyond a particular measurement, then you require treatment based on how low it is. So there is no one treatment for it. It depends, there's a whole spectrum.
So this diabetes, BP, thyroid, these are all lifestyle diseases, right? Which is very much common. How does this affect the overall the bone structure, especially spine and all this?
No, so everything. So if you're diabetic, hypertension not, but diabetes would. Diabetes, your muscle tone is poor, your muscle absorption is poor, your activity levels are poor, and your nerves get affected by diabetes. So if you're asking me specific about spine, then diabetes and thyroid, these are the 2 things which affect, not hypertension. But yes, all of you, rather than the spine, you should be actually, which is important for you as well, you should be looking after these parameters, the metabolic diseases. They are more important to see that your sugars are okay, your blood pressures are okay, your lipids are okay. That is more important actually.
So just, I mean, you know, basic, how does, is there any exercise, I mean, basic level, I mean, to cure, I mean, you are obviously having back pain, that is obvious, and, you know, with this diabetes and all this. So any specific, physical exercise, something? Or it's
Like I told
normal?
you, that there are two types. One is a general exercise like walking, swimming and cycling, and the other are the spinal exercises. It's very difficult because it takes an hour to go through all of them. But whatever little I showed. The neck is easier to show, but you can do that. If you want, you can visit a physiotherapist or look up good old YouTube. Google also will give you some exercises if you don't have a problem, like as a maintenance exercises.
Thank you, doctor.
I think one last question.
Sir, chiropractic treatment is good for back pain?
So see, chiropractic is a different science or different shastra where they look at different things. It is completely different from our system of medicine. So to answer your question is that it can help because they also do some adjustments and exercises, but it is not good if you have a genuine problem. So if you have a mechanical back pain problem, then it can help. And chiropractic is not very well practiced in India actually. It is more of an American phenomenon. So I still feel that seeing an orthopedic surgeon and then going to a physiotherapist under the guidance and doing the exercises is the most scientific way of treating this.
Yeah, last question. Virat.
Sir, in your recent practice, is there any correlation between a person taking COVID vaccine and thereafter having back pain and neck pain?
No.
Because of the uric acid or something, as a parameter going up?
No.
Because in my family, there are 3 people. After COVID vaccine, they have a frozen neck and all other things have happened. So, I don't know, after that only, after 2020 it has happened.
I know, but tell me one thing. Every day the sun rises, right? Barabar. So are you having any correlation that because the sun is rising, they are getting it? What I'm trying to tell you, there is no correlation. People have been getting frozen shoulder for many years. People took COVID vaccine, so now they are trying to correlate. So there is no correlation. There is no correlation. So it's very difficult to answer that question. It also depends on your muscle strength, your weight, your bone structure. But you cannot sit for too long. So I think it is very individual. So there are, like I told you, patient comes to me and said, मैं 3 घंटा बैठता हूँ, तो मेरी कमर दुखती है. So I said, ठीक है, 2.5 घंटे के बाद उठ के walk करो. Thank you, doctor. कितना अच्छा बोला. So it basically is very individual for everybody. It is not, there is no fixed rule or a fixed timetable for that. You have to see what works for your body. So if you feel कि 2-3 घंटा बैठने के बाद back कमर पकड़ती है, don't wait for 3 hours. After 2 hours only walk, do some stretches. So that 2 will then become 4, will become 6 like that. And you have to do exercises, back exercises.
Well, thank you everyone. I formally thank Dr. Samir for coming over here and giving us the brief background of the professional hazards to the back and neck problems that we are going to face or we are currently facing. He also answered the general queries in detail. We are thankful to you. Now, formally, I would ask CA Shah to give a formal vote of thanks.
Before Viral give vote of thanks, just on a lighter note, sir has played very safely. Initially the computer was not working. उन्होंने बोला कोई IT person है यहाँ पे. अगर उन्होंने CA बोला होता तो हम बोलते थे sir 2,500 rupees.
Ladies and gentlemen, I'd like to extend my heartfelt thanks to Dr. Samir Dalvie for enlightening us on the spine-tingling subject of back and neck problems in our world of finance. Who would have thought that chartered accountants could be so spine-challenged, right? Sir, your lecture was truly eye-opening, and I'm sure all our CA professionals are now sitting up straight in their postures and wondering whether their lifestyle choices have been as sound as their financial ones. You've given us the valuable advice that our financial stability should be matched by a solid spinal foundation. Your insights have straightened our postures today. In the spirit of financial responsibility that we all carry and good postures, let's give Dr. Dalvie a round lot of applause that leaves him standing tall in our hearts today. We'll remember to crunch the numbers, but not our vertebrae. Thank you.
Thank you.
Normally we tell people kabhi milna mujhe, but as a doctor it is better to say mat milna. That's my good wishes to you.
you.